Good afternoon and welcome to the Appellate Division First Department. Nice to have you here, all of you, on a beautiful day. I am going to call the calendar. Please remember that we have had your briefs and your record, and we are familiar with the case, so please just ask for the time that you really need for the arguments. We have a lot of arguments scheduled today. The first case on the calendar is People versus Alvarez. Respondent? 4, 1, and 4. Thank you. Nichols versus Governor Hochul. Okay, what about the respondents? Where are the rest of the when I call your case, all the attorneys should stand up. Yes, who do you represent?
Speaker Carl Lisi of the State Assembly, you would request 15 as well.
Board of Elections, you're on the screen, right? The Board of Elections is supposed to be virtually appearing. No? Okay, why don't you have a seat? Let me call the rest of the calendar and then I'll come back to you, okay? I'm not going to do your argument last, but I just want to move it through. The next case on the calendar is MS Real Estate versus Eisenberg, submitted. The next 3 cases are related W. Children. Those 3 cases are submitted. Greenspan versus Stand Up MRI.
No, Dr. Oldenburg.
You're the appellant? Who's the appellant? Oh, there's 2. And what about you? Okay, ma'am, you got to tell me who you represent and how much time you want. I can't hear you. And how much time do you want? How much time would you like for argument, counsel?
Take 10 minutes for the
And who's the respondent? Okay, and who are you? How many appellants?
There's Mark Goldenberg. It was Mark Goldenberg, Pinata at NYU. There are at least 4 appellants. You could tell the appellants to split. Do you think that works to split 15 minutes? And give the reason.
That much?
Well, there are a lot of appellants.
I should have asked you this before.
Yeah.
Okay, the appellants, I'm going to ask you to speak amongst yourselves outside after the call of the calendar, and you can divide up 15 minutes amongst you, and each have 2 minutes for reply. And is there just somebody who's just a respondent?
Yes, Your Honor. I'm going to just take 6 minutes.
Okay, thank you very much. Okay, so if you can go outside and try to divide up that time, that would be good, and we will confirm it before you do that. Thank you. Okay, People versus Dan Soko. Submitted. Cookies on Fulton versus Aspen Specialty.
Representing appellant Cookies.
How much time would you like?
8 and 2,
Respondent? Okay, 6 and 2 and 5. You actually are a cross movement. Do you want response time, rebuttal time also?
Yes, please.
All right, 6 and 2, 5 and 1. You realize that the time is for you. If we have additional questions, we will continue asking them. That goes for all the cases. People versus Sanders. Respondent? Fine, 6, 2, and 6. El Rafael versus Solo Building.
Appellant requests 5 minutes.
And the other parties aren't here, is that correct?
That's correct.
Okay, you may have 5 minutes. Thank you very much. Mac versus Mac? And the other side's not here, correct? You have 5 minutes. Thank you. Velasquez versus Miranda is submitted. ATX Fund versus Paul.
Good afternoon, Your Honor. Appellant requests 8 and 5. Respondent requests 10.
Okay, I'll give you 7 and 2 and 7. If we need more, we will certainly question you. The next ATX case is submitted. That's a related case. Vandergrand Properties versus Warnock. Respondent? 3, 1, and 4. As I promised, you will be heard second after the excessive sentence criminal case, okay? We'll take you out of turn. Thank you. And the last case on the calendar is State of New York versus Warden, the habeas corpus case. How much? We're respondent? Okay, I'll give you 7, 2, and 7. Okay, now, Mr. Quayle from the Board of Elections, is that you I see now?
Yes, Judge, it is.
Okay.
Thank you.
All right, so with all the attorneys on Nichols versus Governor Hochul, stand up and we'll go through this again, okay? The petitioner appellants, yes. And how much do, you each told me you each want 15, and what do you want, Mr. Quayle?
I'm content with just 5 minutes, Your Honor.
Okay, so I'm going, as I said, if we have additional questions, 8 and 2, 6, 6, and 5. And if we need additional questioning, we'll do that, okay? So you may all be seated. I think I've now gotten through the calendar. I hope hearing the arguments won't be as difficult as the calendar. So the first case for argument today is People versus Alvarez. If you please step to the center. Good afternoon, you may begin.
Thank you, Your Honor. Sheila Brown from the Office of the Appellate Defender on behalf of Daniel Alvarez. Mr. Alvarez's 5-year sentence for selling heroin to an undercover officer should be reduced to 3 years in the interest of justice, which would have the practical effect of reducing his post-release supervision. Mr. Alvarez has been a successful business owner in his community, operating a print shop for the past...
How much heroin did they recover at the defendant's house when they executed on the warrant?
Your Honor, there was not any heroin recovered at his house. There was heroin recovered at an alleged stash house, but in any event, Mr. Alvarez was convicted.
How many pounds? How many pounds were recovered?
I'm not aware of the exact number, Your Honor, but there was a significant amount of heroin.
Like 28 pounds?
That sounds right, Your Honor, but of course, because... Oh, sorry.
Loaded firearm too?
Sorry?
Loaded firearm too?
Yes, although the firearm was inoperable in this case. And in any event, Mr. Alvarez was convicted of 1 count of criminal sale and has served his sentence, his prison sentence rather, and has, since his release, has served nearly 2 years on post-release supervision. And while this is not Mr. Alvarez's first offense, he's now in his 50s, and this was his first felony offense in 26 years and first conviction altogether in 19 years. And these offenses have been linked, inextricably linked to his serious heroin addiction that Mr. Alvarez has suffered from since his 20s. And the fact that Mr. Alvarez was able to...
Is there an impact on the defendant's post-release supervision from the Less is More Act?
Your Honor, he may benefit from that act if he continues to avoid any technical violations, but this does not impact this court's ability to reduce his sentence here. Again, Mr. Alvarez has already served 2 years on post-release supervision, and that really should be sufficient. In any event, even if he does benefit from this act, he would still face additional time on post-release supervision. And finally, Mr. Alvarez immediately and repeatedly took responsibility for his actions here. Again, he's in his 50s, and if this court is willing to reduce his sentence, it would allow him to avoid the continued liberty restrictions of post-release supervision. If Your Honors don't have any other questions.
Okay, thank you. You'll have a moment for rebuttal if you need it.
Thank you.
Thanks.
May it please the court, Brent Yarnell for the people. Defendant's arguments for further leniency than defendant already received just don't fit the facts of this case. What he said to the PSI officer that basically his drug use sort of impaired his decision-making capacity just doesn't fit the facts of this case in light of the large scale and the sophistication of his operation. 13 kilos of heroin were discovered.
This particular arrest came after an investigation by Homeland Security and Border Enforcement Security Task Force. Is that true?
That's true. They conducted 2 sales, one in October of 2016, the second in November of 2016. Each of those sales, defendant sold an undercover agent 70 grams of heroin. That's about 2.5 ounces in each sale. And then in December of 2016, December 7th, they arrested defendant and found 450 grams of heroin in his jacket, and then that's when they
That
also...
had been another sale that was about to take place, or that did take place.
Yes, it's correct that it was another sale that was arranged. I don't know if the sale did take place in that third operation, but he certainly showed up with 450 grams of heroin in his jacket, which strongly indicates that he was running a very large and pretty sophisticated drug operation.
The people, the defense counsel is arguing that notwithstanding all of that, in the interest of justice, we should reduce his sentence. What factors would weigh for or against that?
Well, the factor that would weigh very strongly against that is the fact that defendant has already had a second chance. I mean, he's had a previous, this isn't his first conviction, and what he's shown is that he had an opportunity to avoid his life of crime after he served his sentence. He could have lived a life not on the criminal path, and he chose to return back to the criminal path. And he's demonstrated by running such a large operation, not only that he isn't deterred by the threat of a criminal sanction, but also that he's very capable and very willing of running a sophisticated drug operation at a time where, I mean, heroin operations are really it's an extremely grave social ill to have these drugs on the streets. And so I think he's just shown clearly, you know, what's at issue here, as defense counsel said, is whether he'll have those, 2 years of post-release supervision. He has a full 5-year term. The question is whether it'll be reduced. And I think he's clearly shown over the course of his life that he needs that supervision, and the people deserve that supervision to make sure that he doesn't return to drug dealing again, as he did in the past. And I'd note that his 1992 conviction was for a drug trafficking conviction. And then, on this point of, responsibility, I think it's important to note here, what defendant said to the pre-sentence to the parole officer in the pre-sentence investigation report, which is that he was so crazy, that was his word, crazy, as a result of his drug use, that he didn't even know what drugs he was selling, and he didn't even know what quantity of drugs he was selling. That's clearly not true, given how sophisticated and large his drug operation was. Clearly not true that he was that, diminished in his cognitive abilities. And the fact that he's saying something like that to the parole officer absolutely is an effort by the defendant to evade responsibility for his own actions. And certainly that effort to evade responsibility indicates that he doesn't have the state of mind that suggests that he doesn't need post-release supervision. The final point that I would just make here as well is that defendant did waive his right to appeal. He had a very thorough written waiver, and the oral colloquy was totally sufficient. I would just note there was nothing in defendant's brief that identified an incorrect statement that the judge made. Every statement the judge made was totally correct, and there was nothing the judge said that was totally misleading. So we would ask you to affirm on the waiver, but on the merits, this sentence was totally just, and we'd ask you to affirm. Thank you.
Thank you. Counsel, you have 1 minute on rebuttal.
Thank you, Your Honor. Just briefly, of course, because this case never went to trial and the underlying facts, we don't know who else may have been involved or how the police found what they did. But in any event, the convictions that the respondent brings up were from 19 years ago. And in the time in between, Mr. Alvarez demonstrated his ability to thrive without state supervision. An additional time on post-release supervision, as the studies we cite to in the briefings show, would not prevent reoffense after the 2-year period. And just briefly on the appeal waiver, while there was a written waiver here, a written waiver is never a complete substitute for an on-the-record explanation of the right to appeal. The court never explained to Mr. Alvarez what his right to appeal entails, what it means, or that it's a right that's ordinarily retained after a guilty plea. And the court also never explained that this is a right that's separate and distinct from those rights, those trial rights that are automatically waived. Thank you.
Okay, thank you both very much. As I said, we will take Vandergrand Properties versus Warnock out of turn. You may go to the microphone. Good afternoon.
Good afternoon. Thank you, Your Honor. Martin Schell on behalf of the defendant, Robert Becker. Thank you very much for the opportunity to appear today. We respectfully submit that the lower court erred when it granted a landlord summary judgment along with an award of $1 million. We submit that Mr. Becker, who personally guaranteed...
Well, look, counsel, we looked at the guarantee, and the guarantees are pretty airtight. They don't give you too many rights as a commercial guarantor. But what was the fraud here that you're alleging we should have considered?
Well, Your Honor, I think it comes down to two things. It's fraud and interference. The fraud is that basically when my client is signing an extension at about 2018, just to note, Your Honor, there was Robert Becker who PG'd the lease, and there was 13 Floor Associates, which was
Correct.
the tenant. And when that extension was issued, there was no indication, there was no...
What was the duty to disclose that WeWork would be taking over some of the commercial space?
I think that duty, although it doesn't specifically appear in the lease, I believe it's good faith, a part of all contracts, that if you're going to rent to a competitor, you should be telling the person that you're going to issue a lease to a competitor.
I'm sorry. How would WeWorks, which is, I think, an IT-type company, be a competitor to the tenant who himself was a personal injury lawyer who sublet different parts of that floor to other professional lawyers and accountants? A, how was that a competition? And B, why would the landlord know that WeWorks would be in competition with lawyers and accountants. I mean,
I think there's twofold, Your Honor. One, we didn't have any discovery to even address what the landlord knew or didn't know, and I think we should have had that opportunity. But I would say, fairly common in the industry in New York City, WeWork is known to sublease pretty much to anyone. Lawyers, anyone who needs working space can go to WeWork, and that is basically what my client does. Robert Becker subleases. Yes, he generally focuses on lawyers and accountants, but he has space to fill, just like WeWork has space to fill. And he was there for 30-plus years, working with the landlord, and here, when they're about to enter into a 10-year lease, they lease a third of the building, surely to people that are going to take clients away.
Would there be any scenario where the obligation would be on Mr. Becker to inquire as to who the tenants are going to be in the building?
I don't think so, given his long-standing commitment in the building. He's been there for a very long time, and if the landlord is going to be, again, the landlord knows what they're doing, the landlord knows who they're going to be leasing with, and I think that obligation falls on the landlord.
But didn't you give that obligation away by the terms of the guarantee?
I don't think so. According to Canterbury Equipment Corp., I don't think that was given away. I think that case stands for the fact that if you are going to interfere with...
At best, it's a defense for the tenant, but that doesn't inure to the guarantor's benefit.
I believe the outcome of that case clearly went to the benefit of the guarantors, who signed guarantees very similar to the guarantee at issue that waived all rights, any objection, and that case specifically said that we're not going to hold the guarantor liable, at least on the summary judgment level. Perhaps after trial they would be held liable, but at this point in the case, without having any discovery, we submit that summary judgment was granted prematurely.
The bad acts, if you will, in Canterbury are sort of a different nature, aren't they? I mean, the plaintiff causes the default by allowing loans in excess of the credit limit, and then accelerating the loan on the ground that the plaintiff had exceeded its credit limit. They sort of like caused it. It's not what you have here that is perhaps a failure to disclose what you think should have been disclosed. There's an active wrongdoing in Canterbury, which you don't have here.
I think there is an act of wrongdoing, respectfully, Your Honor, and I think that act is not disclosing WeWork. And my tenant moved from the 13th floor to the 15th floor and got a subpar floor, a very old, decrepit bathroom. They built a bathroom in the middle of the space, and there is evidence that this resulted in the loss of business from customers, clients, attorneys breaking their leases and leaving. So as a result, we think it is on par to Canterbury.
Okay, thank you. You'll have a minute to respond. We'll hear from the respondent.
May it please the court, Henry Masho, Rivkin Rattler, attorney for plaintiff Vandergram Properties. Supreme Court got it right.
Is this a case like Canterbury?
Not at all. Canterbury, in this case, the defendant specifically waived any defenses that the tenant might have against Vandergram. And the whole basis for their claim is that Vandergram didn't treat the tenant properly.
Well, did this rise to the level of fraud? I mean, they've been in your business, in your building for 30 or 40 years, running the type of business that you probably knew they were running. They weren't filling the whole space with their own law firm. Right. And WeWork, developed much more recently, and, we know what they do. We have, sure. So wouldn't that be, wasn't that sort of a fraudulent misrepresentation to the tenant, long-term tenant?
Not at all. This court's case law talks about misrepresentations, and there's no allegation that Mr. Becker asked who the neighbors would be, and there's no allegation that Vandergram misrepresented any facts. And
just didn't tell him.
It was an omission, and that's not enough for a fraudulent inducement claim.
Was there any duty to disclose that, though?
Not at all. Not at all. No case has ever, from this court or any other, has held that a landlord has a duty to its tenant to reveal the identities of other tenants. And this court shouldn't be the first to come to that conclusion. That would cast a fog over all the landlord-tenant relationships that are here
throughout. There is no
city.
competition clause in
Not
the
at all.
agreement that you
Nothing
have.
of that nature. And I'll just close with one final point. The context is important here. Mr. Becker could have limited his liability under the guarantee if he had had the tenant surrender possession back to the landlord. That would have cut off his liability. But he didn't do that. Instead, he continued to do business out of that office and did so without paying any rent. So it's entirely fair that he's responsible now for that rent.
Okay, thank
Thank
you.
you.
Counsel?
Thank you, Your Honor.
So you don't think that your client had some obligation to do some due diligence to see what was going on in the building with the new rentals?
I don't think so, Your Honor, because how would he really know that? I think the point, as Your
He's
Honor
got to
said,
do some due diligence.
well, but it's an omission, and it's not just, it's a
Well,
glaring.
if this mattered to him, he should have sought a representation about it.
Well, but I think who is the onus better placed on? My client who's been there for 30 years and has a relationship, or the landlord who knows exactly what their dealings are, knows who's coming in and out of the building, and to say to my client, hey, fair warning, I'm bringing in a competitor. And I think the important thing here, Your Honor, is this is not like a 5 or 6 year term. This is 30
Is the landlord
years.
under an obligation to refrain from renting to someone because, in order to keep the other tenant's business lucrative?
Well, I think my client should have been left with the decision.
It's not an unreasonable requirement if it's negotiated. You put into the lease, you're not going to rent adjoining space to someone who's going to undo my business.
Well, but I think the goodwill and good faith that was established over 30 years included that. Every contract requires good faith. For you to say I'm going to rent to you and then rent to a direct competitor, that's not good faith.
Okay, any further questions? Thank you both very much. Okay, Nichols versus Kathy Hochul, Governor Hochul. Mr. Quayle, can you hear us?
Yes, Your Honor.
Okay. That's weird.
Good afternoon. May it please the court, my name is Jim Walden, representing all the petitioners here. A pleasure to see you all, and thank you for having us. There's no question that the assembly map is unconstitutional. Judge McAllister in Steuben County declared as much. The Court of Appeals.
Yeah, but he got reversed, didn't he, by the Fourth Department?
Yes, he did, Your Honor. But the Court of Appeals in
And then I thought that your clients never really appealed that aspect of the Fourth Department decision to the Court of Appeals. Now, we all know about the footnote in the Harkenreiter case, but that's a footnote.
Yes, Your Honor. So they weren't my clients, Your Honor. We weren't in the case at the time. We represented interveners there that
True,
got denied.
I'm sorry, that's
No,
correct.
not at all. So it's a complicated.
But the
factual
issue was,
case.
I mean, the petitioners in that case never appealed the reversal by the Fourth Department when they went up to the Court of Appeals. That was not one of the issues.
Yes, Your Honor, but the point is that the Senate map was declared unconstitutional by the Court of Appeals for the same reason that the Assembly map is unconstitutional. Period, full stop. It's very clearly a violation of the Constitution, and everyone was on notice, including these respondents, that once the Assembly map was in play, they should have been planning for an Assembly election under a different set of maps. And they didn't.
When the Court of Appeals made their ruling and it was limited specific to the congressional map and the Senate map, and then as my colleague indicated in the footnote, makes reference to the Assembly map, in that particular case, in the Harkenreiter case, there had been a whole series of due process steps that had taken place before the Court of Appeals rendered their step. We're here with just an order to show cause at this point, and now you're seeking a declaration that the map is invalid without that due process. How should we look at that?
Well, Your Honor, there are two very different issues. You're right, in that case, the judge ultimately had a very short trial. But in this case, the law is already settled. The Senate map suffered from the same constitutional infirmity as the Assembly map. And so when one is declared invalid, although the Court of Appeals did not reach the Assembly map except in a footnote, the reasoning still applies. With respect to the congressional map, there was an additional allegation there of gerrymandering. Right. That didn't apply to the Senate map. That's why the Court of Appeals footnote is so important. They said, although the Assembly map suffers from the same constitutional infirmity, we can't give relief here, which is why we sought to intervene to get it, and when we were denied there, we brought this plenary action.
But I do wonder, and Judge Love discussed this in his decision, I dare say that you were aware that this case was going on in Steuben County, the Harkenrider case. Why didn't you seek to intervene before you sought to intervene? Why didn't you seek to intervene in February when the case was starting rather than after the Court of Appeals decision when it was so close to the primaries?
Well, Your Honor, if we're going to get to the laches argument now, and we're going to take the delay piece first, I want it to be clear that the only delay that was attributable to the petitioners here is between February 5th and March 31st. That's it. I haven't found a single case that says that that's unreasonable or inexcusable delay.
But I mean, honestly, these are election-type cases, and we know the time frameworks are very, very tight, as opposed to, you know, if it was another kind of case, I would say, yeah, you're right, but it isn't.
Also, counsel, I'd ask you to defend that premise because on March 31st, that's when the trial judge, sua sponte, raised the issue of assembly maps. That's, as it turned out, kind of a fragile basis, and it was overturned. So why not intervene then? Your clients, at least two of your clients, were tweeting about this whole issue before March 31st.
Yeah, well,
why not intervene and like just protect your interests?
So, Your Honor, again, fully concede that for the period of time until March 31st, they did not intervene. And they didn't intervene because they were getting up to speed on the case. They didn't have counsel right away. And on March 31st, as they were still evaluating, the judge declared the assembly maps void. And I don't think that Judge McAllister would agree with Your Honor's assertion that that's a slender basis. It was the same constitutional violation in the Senate map that was true in the Assembly map, so he felt duty-bound to invalidate both. Now, the Fourth Department reversed him, but clearly the Court of Appeals could have reinstated Judge McAllister's decision. The problem is that they have unclean hands, which is why laches should never apply. There's a constitutional violation.
But you'd concede, I mean, obviously the Court of Appeals did not do what you just suggested could have happened, correct?
Yes, Your Honor, but they were on notice that the assembly maps were in play, and they did nothing because the assembly maps were the prize all along. They wanted the assembly maps. That's why they never challenged them in Steuben Court, because there was a political compromise reached to leave the assembly maps alone, despite the fact that they were unconstitutional. And so when that information got to our clients, that's when Mr. Greenberg first moved to intervene 4 days after the Court of Appeals decision.
Even if we buy all that, it's now June 9th. Early voting starts in 9 days. The people have, people have spent a lot of money getting petitions, getting signatures, doing all the things they do, getting things that you get sent in the mail, flyers, all that kind of stuff for running for all the various elections. Out of the overseas ballots, the military ballots, they've been out for a long time. This is a massive, mess that you're asking us to stay this election in less than 3 weeks, in less than 3 weeks before the election.
Yes.
Don't you think that under these circumstances, this is just a little bit too late?
Your Honor, I don't think that it's too late,
but
that is not the only alternative here. So this map is going to be valid for 10 years. That's what they want, 5 unconstitutional elections. So what Justice Love should have done, if he felt as though it was too soon for the 2022, is to either schedule a special election in 2023 or have a new map drawn and applied for 2024. It cannot be the case that because my clients delayed less than 2 months, that the voters of the state of New York have to endure unconstitutional maps for 10 years.
So let me ask you something. If we were to find the assembly map invalid, what would be the next step? What would happen next? Would you have to continue this procedure, or would you think that it would just go back to the Constitution? In 2014, they changed the Constitution. They came up with this new procedure. You're claiming that wasn't followed. Seems like a lot of people agree with you. Is that where they go back to the Independent Redistricting Commission and start there again and create new assembly maps?
No, Your Honor. The Court of Appeals clearly foreclosed that option.
For this?
Well, the Court of Appeals held, with respect to the congressional district and the Senate district, the Senate maps, that the Constitution requires judicial intervention at this point. The assembly map is no different. So, but there are 3 options. Option number one is to send it back to Justice Love to actually hold a hearing on burden, because I believe, Your Honor, the special master redrew the Senate map in 18 days. So
We
this.
we don't even have 18 days. Oh,
What-
you're
what are
saying
the
we
other
should
two
put
options?
this, we
Yes,
should
if
put
there was
this
a
one
yes,
up.
if there was a TRO, this could easily be aligned with all the other elections and reduce voter confusion, because instead of having multiple primaries, there would just be one.
Would we run into any time frame constraints in terms of the general election?
The schedule,
November?
Your Honor, it's a very, very fair question, but the schedule can be achieved. It is achievable. And what we asked below was that for the court to actually hear how that can be done, and the court refused to do it. But that's not the only option. The court could declare the map unconstitutional and invalid, but under the cases that we cite in our brief, you could say it's too late for 2022, but either you could
The respondents very strongly argue that you failed to request that relief in your petition.
That is incorrect, Your Honor. Their record site is in our brief, and I can give it to you right now. We made that argument specifically below, and we preserved that argument. But, Your Honor,
Could you finish that last, I'm sorry, but could you finish the last answer you were giving? I asked you if we found it to be not valid, the assembly maps pursuant to what the Court of Appeals footnote implied, what, does it have to go back to a court? What would a court have to do, or does it just go back to the procedure that was the constitutional new procedure from 2014?
no, Your Honor, there are three options. Option number one is the option that may be unpalatable, which is to stop the current election. That's not the only option. Option number two is this court could, or the lower court could, declare a special election, truncate the terms of the people that were voted in under unconstitutional maps, and hold a special election in 2023. The third option is to not do that, but to have the map redrawn by the special master and deem it applicable as of 2024.
Why isn't it an option for it to go back through the constitutional process and then return to the IRC and then subject to any amendments?
Because the Court of Appeals has already declared that that is not appropriate under the
But that was not appropriate under this circumstances where everything was such a rush. I mean, the Court of Appeals said, go back to Steuben County. The judge asked a special master to do this because this was really a time thing. But if you're saying maybe we'll deal with this in 2024, isn't there plenty of time to go back and do the process the way the process was set up?
Your Honor, I believe that the Court of Appeals description is on page 14 of their opinion, and they said very clearly it's not a matter of timing, it's a matter of constitutional process. Once the time frame for submitting the second map is over by the IRC, the independent, and at that point, if there's not an approved map, then judicial action is required. So in the Court of Appeals case, the respondents asked exactly what you're proposing, and the Court of Appeals said flatly no with respect to the congressional map and the Senate map. There's no difference between the maps. They're all subject to the same constitutional provision. Should I now finish answering?
Judge Friedman's.
Yes. So I will look up the site because it's buried in my papers, but Your Honor, we did preserve that argument, and it has to be preserved even if I didn't say it explicitly in the record below, which I did. It's in the transcript. The whole relief here is to invalidate the map for all times. So their argument that we were only asking for 2022 is wrong. Procedurally below, we were asking for a TRO for the 2022 election, but we weren't in any way, shape, or form saying anything other than that the map is invalid for all of the subsequent 4 elections until the next redistricting. So the fact that we're now saying, okay, if you can't do it in 2022, do it in 2024, that's what they asked the Court of Appeals to do. That's what the respondents suggested, is that the Court of Appeals delay any relief with respect to 2022 for the Senate and the congressional maps, and the Court of Appeals declined that invitation and said, no, that wouldn't be appropriate because there's enough time. But here, if Your Honor feels as though there's not enough time for the 2022 election, we did preserve it, we did argue it, and it is appropriate to have the special master redraw the map and make it applicable at least to future elections. That way, voters do not have to endure 5 elections of constitutionally infirm voting. That only destabilizes the state of New York and brings damage to us, which is another reason that latches shouldn't apply.
Okay, we gave you some extra time. Thank you very much. We'll hear from counsel for the governor first. Is that correct? Okay, thank you.
Thank you, Your Honor. Andrea Trento from the Office of the Attorney General. For Governor Hochul, may it please the court. A couple comments on counsel's prejudice argument. I think that the contention that March 31st is the operative date, or the time before March 31st is the only relevant time period for which prejudice can be attributed to the petitioners, is not correct. Because March 31st was the date that sua sponte, Judge McAllister, issued his ruling on the assembly map. But there was no party involved in that proceeding at that
The law
time.
went into effect on February 2nd, correct?
That's correct, Your Honor.
And they don't bring a challenge for 3 months.
That's correct, Your Honor. Your Honor, I think the latches, that is to state that time period is to refute the argument. I think there were opportunities during the course of those appeals when none of the petitioners who were party to that case were advocating, were in a position to advocate, had pled for the unconstitutionality of the assembly map. Somebody had to advocate for the judge's ruling on appeal. Nobody was party to that case. That was an opportunity for these petitioners to intervene and to seek to advocate on behalf of their rights. The other point is, even after the Court of Appeals had ruled, the petitioners had a choice at that point. They could have chose to seek intervention, which they did, and that was probably the right choice because Judge McAllister was best positioned. Judge McAllister had done the work. He had retained the special magistrate. He was best positioned to effectuate.
So the Court of Appeals has indicated in no uncertain terms that it regards the assembly lines as invalid. Even if everything you say about latches is accepted by us, what are we to do with the fact that the Court of Appeals has said that the assembly lines are not valid?
The Court of Appeals did not see fit on the strength of their reasoning to overturn the assembly lines. So that's point one, Your Honor. Point two is this case is about 2022. The four corners of the petition seek relief as to 2022. The TRO that was sought below seeks emergency relief as to 2022. This isn't a case on the four corners of the pleading about 2024.
Well, what happens? Does the constitutional process then kick in if the map is found invalid, or does it get remanded, or nothing?
Your Honor, I would point the court to Section 5B of Article 3 of the Constitution, where counsel seemed to indicate that there was the Court of Appeals foreclosed the return to the IRC constitutional process. I think it's correct, as Your Honors were mentioning, I think it's correct that that had to do with 2022, because Section 5B, subsection A, says honor before February 1st of each year, ending with a 0, and at any other time a court orders that congressional or state legislative districts be amended, an independent redistricting commission should be convened according to all the...
So you're saying a court could direct that process begin again?
A court could indeed do that. It's authorized under the Constitution to do that.
Could the court do that in 2023?
That's not this case.
I'm just
There may
asking
be
a
a
question.
case that comes forward
It's not barred by the Constitution, is it?
Sorry.
In other words, if a court could make such a direction that the IRC convenes in 2023, and that would not violate the constitutional provision that you just cited, correct?
It does not seem to violate the face of the constitutional provision I just cited.
But that would require a special election at that time, since the next assembly...
It's nothing to do with a special election. A special election presents a whole host of issues that are not before the court, were not in the record. Counsel seems to suggest this court can just snap its fingers and order a special election for 2023. That wasn't pled in the petition below. We had no opportunity to develop a record to explore whether latches should also bar that kind of relief. It's just not before,
You make that point. The petition does not, in fact, relate to 2023 or 2024. It does say declare the lines invalid for 2022, but it doesn't talk about what should happen in 23 or 24.
Yes, Your Honor. The effort to essentially get this court to amend the petitioner's pleading for them is inappropriate. They engineered the very direct appeal that they sought before the Court of Appeals by asking the trial court to deny the petition as a whole.
So what effect does that have, asking the judge, which he did, based on their request, which he mentioned at the end of his decision, to deny the petition as a whole? What effect did that have?
Well, I think it means they're judicially stopped from going back on that request here. They obtained the relief they sought from the trial court, which was a denial on the merits of their petition. Now they're trying to backtrack on that because it didn't work out for them strategically.
But the thing is, in looking at the petition and in looking at the order to show cause, they do ask that the 2022 map be declared void. But the 2022 map was theoretically going to be the map that was used for, up until the next map is created 10 years from now. So it didn't say just for the 2022 election. It said the 2022 map, period. So why does that not mean the map going forward? So if it's declared void, then it would affect, we would have to do something in the future.
Well, Your Honor, they seek various remedies associated with their request for relief as to 2022. For instance, they ask for that a special master be appointed to draw a new map because, as the Court of Appeals said, there's just the constitutional process was no longer possible for 2022. For that reason, it's just a different lawsuit that's not before this court. Unless the court has further questions, I will rest.
Thank you. Thank you very much. Counsel for the Assembly and the Senate leadership. Good afternoon.
Good afternoon, Craig Buckeye, and with C. Daniel Chill and Elaine Reich, we are co-counsel to Assembly Speaker Carl Heastie, and I would like to pick up where Mr. Trento left off, that in order to have invalidation or any kind of remedy with respect to 2023 or 2024, it needed to be pled properly, and the arguments needed to be preserved for the record, and they simply wouldn't. And I think the point of this entire argument is that process is a two-way street. Mr. Walden goes on saying, well, the Court of Appeals found that the Assembly map was procedurally infirm, and what the what the Court of Appeals said in footnote 15 of its opinion in Harkenrider speaks for itself. But process is a two-way street, and so if one were to bring a lawsuit seeking to invalidate the Assembly map, one needs to satisfy certain criteria, and the Court of Appeals recognized that in footnote 15. They said, look, the Assembly map was not challenged here, and in order for us to invalidate the map, there needs to be a proper challenge, and at pages 341 and 342 of this record, it's clear that in Harkenrider there was no challenge to the Assembly map, and that's why the map was not invalidated at that time. Second of all, the challenge needs to be brought in a timely fashion. It is clear from the record, from all the tweets from Mr. Wax and from Mr. Greenberg, they knew what was going on in this litigation, and in fact, there was one point in time that Mr. Greenberg actually tweeted an image of the petition itself. So obviously he saw the petition, and if he would have read it, he would have seen that it said, we're not challenging the Assembly map. And so if people weren't challenging the Assembly map, he had plenty of opportunity in February and in March to intervene at that time, and I would have expected that Justice McAllister would have allowed intervention at that time. But even though Justice McAllister sua sponte invalidated the map March 31st, that determination was later overruled. Then when it came to May, he said to allow intervention at this point now would create total confusion because of that issue of latches, the combination of the delay along with the prejudice. And the prejudice is really to the voters. And the Uokava statute was mentioned in passing earlier in this argument, and that provides that 45 days before the election, the absentee ballots need to be sent out, and we are well past that deadline. And in addition, what's new for this year is that the canvassing of the absentee votes is taking place as the absentee voting period takes place, rather than having to wait until the election is concluded, and that's under the brand new revision to election law section 9-209.
Counsel,
Go ahead.
you also make the point that the special master in the Harkenrider case took 32 days to prepare maps. Why would that be the case here, since we're just talking about the Assembly and presumably the computer programs that he used, or she used, I forget, for that would be easily applied here? Why isn't that a matter of days?
Why I think it would take at least 32 days is that there are 63 state Senate districts, and there are 26 congressional districts. So if my math is right, that's 89 total districts. Assembly, there are 150 districts. So we're not talking about twice the number of districts, but we're talking about a magnitude higher than 89, and it took the Special Master Service 32 days to put together the maps. And so let's say that today, which would be unrealistic, but let's say today a special master were appointed. I think it would take a month for a special master to come up with maps, because it's not just a matter of the special master waving a wand and coming up with maps. There needs to be public input. So for example, in the first week of May, anyone from the state of New York was invited to come to Steuben County Supreme Court, and I was there, and to give their comments as to how the map should look. So first, the special master needs to give people a fair opportunity to be heard in that kind of a public hearing, and then the special master does his or her work, and then the special master releases proposed maps, and then there's a second opportunity for comment after that. And then a few days later, after some more revisions, then the map comes out. So realistically, this is a process that would take at least a month, I would submit, and that would take us, if you were starting from today, into July. And then there would need to be an opportunity for ballot access. And we're not just talking about New York State Assembly candidates. We're talking about candidates for party district leader in New York City, New York State Democratic Committee, county committee, because you need to live in the right assembly district, and perhaps even more important, judicial delegate and alternate delegate. So are we not going to have judicial nominating conventions for state Supreme Court this year? That would be ridiculous. And the thing is, the ballots for the general election, and that date can't be changed, the ballots for the general election under UOCAVA, whether under the federal UOCAVA or the state analog of it, need to go out by September 23rd. So even if you were to have a September primary, there would need to be an opportunity for the petitioning, for the recounts in case there are any primaries for judicial delegate or alternate, and then you need to be able to convene a convention. And we all know, for example, from a few years ago in the Queens County District Attorney race, those recounts can take a while. And so, you know, it's unrealistic to think that a September primary would be possible, and still it would be possible to comply with the UOCAVA statute. And
Counsel, so assuming that we agree with you on the issue of latches and the special master not being appropriate, what is the next step? Is it to send it back for the IRC to redraw the map, or nothing happens for 10 years?
Well, I would say in this particular case, the next step should be dismissal of the petition, the affirmance of that. And the reason for that lies at pages 907 and 908 of the record. And that is Mr. Walden's letter from May 24th that he sent to Justice Love. And in that letter, he said to Justice Love that given the exigencies of time, and I'm paraphrasing, of course, that if Justice Love was not going to issue a temporary restraining order, postponing the election, putting everything on hold, he specifically asked that the petition be denied.
And that's what happened. And so you're asking us to affirm that. So then what happens? I mean, then what happens after that? Nothing?
Well, if the petition is denied, then the petition is denied.
What if this court felt constrained to say that the assembly lines were invalid? So then what happens? And the petition is dismissed. So then, does there have to be another lawsuit? Does the IRC procedure start anew? What happens?
We would submit that there would have to be another lawsuit based upon the procedural setup that was propagated by the petitioners in this case and Mr. Walden's letter at pages 907 and 908. And in that other lawsuit, what we would submit is, number one, to change the district lines for 2022 is too late. Number two, with respect to 2023, if anyone were to desire a remedy for 2023, that lawsuit would need to name necessary parties, which would include all of the candidates whose two-year terms would be truncated into one-year terms under this court's ruling in matter of Clinton versus New York City Board of Elections. Or,
so what you're saying is that the letter at page 907 of the record, which was probably an attempt to get the case to the Court of Appeals as quickly as possible, that you believe that the petitioner should be held to that letter, that that's the roadmap he had sketched for this case, and he should be held to it.
Absolutely. There's an old saying, if you make your bed, you have to sleep in it. And that's exactly what the situation that Mr. Walden and his clients find themselves in. And so we would submit, yes, the dismissal of the petition should be affirmed because in that letter, they very narrowly presented a choice for Justice Love. Either put this year's election on hold or dismiss the petition or deny the petition because, as they said, and I'm quoting from that letter, they said, quote, all arguments to grant or deny the petition have been heard. And there were no arguments concerning 2023 or 24. And then they said, petitioners, and I'm quoting, respectfully ask that the court decide the petition and enter a final judgment in order to facilitate a speedy appeals process. And in fact, they said in this letter that their goal was to get straight to the Court of Appeals and bypass this court. And the Court of Appeals then a couple of days later told them not so fast. This case does not only present a constitutional issue. So this was the situation that they made for themselves, and we would submit that in another lawsuit, if there were to be a challenge with respect to saying, you know what, we're going to leave the assembly lines alone for the next 2 years, and let's talk about what will happen in 2024, then at that time, there should be a full and fair opportunity for the parties to make their arguments and develop a record, which was not developed before Justice Love in this case, as to whether, as Mr. Walden would submit, the judge should draw the new lines with the assistance of a special master, or, as we submit, whether in fact the commission should be reconvened under Article 3, Section 5-B, sub A of the state constitution to allow that commission process to proceed.
But that lawsuit would seem to start with the fact that Harkenrider has already said the lines as presently drawn are not valid.
Lines as in the assembly lines?
The assembly lines is presently drawn are
And I would
procedurally
say
invalid.
the language that the Court of Appeals used, and I'm not going to put an interpretive gloss on that, is in footnote 15, the Court of Appeals said, the lines are procedurally infirm, but we are not going to invalidate them because they were not challenged. And it would have been well within the purview of the Court of Appeals if they thought it was appropriate to invalidate the lines at that time to do so, but that's because process is a two-way street. And in order for Mr. Walden to get the lines invalidated for this year, he needed to bring a timely challenge, he needed to have petitioners withstanding, he needed to join all the necessary parties, he needed to satisfy the statute of limitations, and with respect to the 2023 and 24 arguments, he needed to plead the request for relief and preserve his arguments for appellate review.
Okay, thank you. Thank you very much. Mr. Quayle?
May I please support? Thank you, Your Honor.
Okay.
My co-counsel did an outstanding job at covering most of the points that I was going to cover, so I will be very brief and, of course, available to the court to answer any questions that the court may have. Fundamentally, though, there are just a few timing considerations that we outlined in our brief that we'd like to underline and underscore for the court. We are indeed 9 days away from the beginning of early voting and 19 days away from the scheduled date of the June 28th primary. At this point, it is not possible to parse the primary and remove assembly candidates from that election. It is just not something that can realistically be done, given the fact that ballots have been sent as of May 13th to military voters. Tens of thousands, many tens of thousands of absentee ballots have been issued, and thousands of those ballots have been returned.
Mr. Quayle, this is
Yes.
Justice Moulton. So what you're arguing is, I guess, is that the state faces the possibility of the introduction of a great deal of error if we were to try to rush the redrawing of the assembly maps. And we have no idea about the panoply of error that could be entered into the election that way.
I think, Your Honor, that is a fair assessment, and if anything, greatly understated. I believe it is impossible to parse the July 28th primary and have it run in any manner that would be a credit to democracy. It would be quite impossible to do. Which leads us then to the second piece, Your Honor, which is if we could parse the assembly contest out of July, could we put it in August? And there really are just two dates that I would call to the court's attention. At this point, we are 29 days away from the mandatory ballot transmittal deadline for military and overseas ballots. It's been noted that it took the special master below 32 days to even come up with lines. But let's just say that's a squishy number. Maybe it could be less. Maybe you could have a special master that would rush. Once you have the lines, you need to have a ballot access process and a challenge process, and some administrative time to actually produce the ballots that you need to transmit to military and absentee voters, and then obviously then to actually hold the election. And the problem is that cannot be done in a scant 29 days. And I would point your honors to Judge McAllister's first decision of May 31, because about 3 or 4 pages into that, he talks about this. And he talks about how on May 31, when he issued that decision, that he was running out of time to have an August election. He talked about the problem with moving into September in terms of getting ballots to military voters in time for the general election deadline. And he obviously at that point had rejected the idea, quite rightly, that it would be possible as of March 31.
Wasn't his decision March 31?
Yeah, did I
Does it
misspeak,
say
Your
May
Honor?
31?
Oh, I was completely incorrect. It is March 31, Your Honor. As of March 31, he was saying that there wasn't enough time to change the primary for June 28th. He knew, of course, that there were more processes left in that case, because it was obviously going to go all the way to the Court of Appeals, which it did. But he recognized that there wasn't enough time and for June, and he also recognized that there were issues moving into September with ballot transmittal in time for November. So he concluded the only time that would be possible would be in August. Ultimately, he set the date at August 23rd after it came back from the Court of Appeals, and he recognized then that it was nip and tuck to get it done. And at that point, he had scheduled initially the maps to be done by the 24th of May, and ultimately, at the request of the Board of Elections to expedite in any manner possible, he actually trimmed it back to May 20th. And I think he provided for as expedited a process to add the state Senate maps into the mix as he possibly could and undergo the type of process that Mr. Buckeye described in terms of public input and all the rest. We simply don't have time for that at this point. There's a difference between March 31, April 27th, when the Court of Appeals came down with their decision, and now well into June. If there are any questions, I'd be happy to take them. Otherwise, I'll conclude.
Okay, thank you.
Thank you.
Mr. Walden?
Your Honor, the other side had 20 minutes. I'm just going to give you some information that I promised, and then I just have a couple things to say, so I'll try to be brief. First of all, I promised a cite that we preserved our argument. It's at the record at page 1014. It's the underlying transcript, and I'm going to quote, although I think it may be a slight paraphrase. We're asking for relief, quote, not just for this election, but for the next 10 years, end quote. So, second thing.
That's the transcript before...
Justice
Love?
Love, yes. Secondly, someone quoted the petition as saying that we were only asking to declare the lines invalid for 2022. That's not correct. We asked for the invalidation of the lines, period, which would affect all of the subsequent elections. Third, I promised Your Honor a cite to the Court of Appeals decision on why it can't go back to the IRC. That's at page 12, not page 14. I'm going to read very briefly. The Constitution explicitly authorizes judicial oversight of remedial action in the wake of a determination of a constitutional infirmity. So it's very clear under the Constitution that the right next step is a declaration and then a process supervised by the court to make sure that the legislature doesn't pull this stunt again. Mr. Buckey, I want you to understand, has some sleight of hand in his. He said, oh, we asked for the denial of our petition. Then he read the language. I hope that Your Honors recognize the difference. We asked for a decision, not a denial. The record's absolutely clear. It's in writing. And so their claim that we asked for it to be denied, they're just making that up out of whole cloth.
You just wanted a final decision, is that?
Yes, and what we hoped was that he was going to declare the Senate or the Assembly map unconstitutional and then decide what the right relief was. There have been various statements here, and I don't understand why they keep saying this to the court, because I find it outrageous.
Well, wait a sec, wait, I'm sorry. So you wanted Judge Love to declare the lines unconstitutional and then figure out what was the right relief?
Yes.
So is that what you want us to do?
Yes, Your Honor. I mean,
If we did, I know I've asked this question a lot of times, but if we did find the lines invalid, what do you think our options are?
So let me just say, in response to that, Your Honor, what Mr. Quayle just told you is so incredibly misleading. They had, once they got the lines from the special master through that whole process, they had from May to August for the election. That's how much time they had. Right now, we're in June, and we're asking to move all of the state primaries, only the state ones, not the congressional ones, to mid-September, which is the historic one. They have the exact same amount of time in this election that they did once Judge McAllister had final lines in that case. The time frame is exactly the same. So we're not asking for anything outrageous, and they keep talking, and this is what I was going to say before, Your Honor, about the federal statute, military ballots. It's irrelevant. It only applies to the congressional races. We're not asking for any relief with respect to the congressional races. And the court has inherent authority, as legions of authorities have said, to change all state deadlines if there's a constitutional violation. And honestly, I believe that that is exactly what should be done here. But whether this court does it or you send it back to Justice Love, assuming that you agree that the lines are invalid for the exact same reason that the Court of Appeals has already found the Senate lines invalid, I ask you to please keep open the door to not subjecting the voters of this state to exactly what the Court of Appeals was trying to avoid.
But okay, so if we find that we don't want to stop the June 28th primary.
Yes, Your Honor.
And that something should happen in the future.
Yes, Your Honor.
What's the basis for appointing a special master? That was done because it was a rush. It wasn't going to go back to the other process. So they said, okay, that was Judge McAllister's idea. He appointed a special master, and they did it, very quickly, and that's how they're doing that. Under what theory would that be like a paradigm to have that done again?
Your Honor, that wasn't done because of the rush. It's done because the Constitution requires judicial supervision over the redrawing of the lines.
But one of the things,
that's what he chose.
And the quote that you just read on page 13, it specifically references at this juncture, meaning the juncture, the time constraints that the court was dealing with. That's the preceding part to the quote you just read. So what you just said is a little bit misleading. At this juncture, we're at this juncture. There's no time for that.
I'm sorry, Your Honor, I don't have the full case in front of me, so I apologize if I'm messing something up. But
I do have the full case.
No, I understand, Your Honor. The at this juncture means now that we have declared the statute unconstitutional. The Constitution requires the next step to be judicial, not going back to the IRC. So to answer your question now, Your Honor, the appropriate thing to do if you do not want to disturb this election is to allow the special master to go through that process and have that process applied.
Couldn't a judge do something other than appoint a special master?
I'm not aware. I don't know how a court would have the expertise to use the software that, Your Honor.
Well, I'm not suggesting that the judge has to do it, but that was the only choice the judge has, to appoint a special master to draw the lines?
Judge, every election case that I know of in this posture, the courts use a special master or an expert, even if they're not called a special master, to judicially oversee the redrawing of the lines to eliminate the constitutional taint.
Okay, any further questions? Okay, well, thank you all very, very much for the argument. It was very helpful, and thank you for coming in. Okay, now the next case that is going to be called is Greenspan versus Stand Up MRI. So if all the council will come here, the reason I had a little problem calling this case was both Justice Moulton and myself are recused from this case, and Judge Gesmer will appear instead, and she's going to be on the virtual screen. Okay, so Judge Moulton and I will see the rest of you later. Thank you.
And in the event that there's a tie vote, a fifth judge will be vouched in. So the appellants were to split 15 minutes between themselves. Have you come to an agreement as to your time? Okay,
4, 4, 1, and 6.
4, 4, 1, and 4, 4, 1, and 6?
And then with the rebuttal time.
Okay, so who's going first?
I am, Your Honor.
Is that stand-up MRI?
Actually, Dr. Goldenberg.
Go ahead.
It's Gary Dwyer and Taglia for defendant appellant, Dr. Alec Goldenberg. And the appellant respectfully requests a reversal because it's clear that there was a lack of causation in this case because the alleged negligence as to Dr. Goldenberg, who was an oncologist who saw the patient 2 months before in his office and then later in the hospital, he's charged with not performing a PSA or a rectal exam and diagnosing metastatic prostate cancer, yet his alleged negligence is not causally related to the plaintiff's paralysis that occurred 2 months later in an MRI scanner. And the reason is...
Counsel, this is Justice Gesmer. I have a question.
Yes, Your Honor.
It seems to me that the most significant failing attributed to Dr. Goldenberg is not related to the PSA, but the fact that he observed that the January 5th, 2015 PET scan was consistent with bone metastases and malignancy, but he didn't communicate that to anyone. Isn't that correct, that he didn't do that?
Well, Your Honor, one of our points in our brief is that...
Counsel, could you answer my question?
That's one of the allegations, but Your Honor, we moved specifically on causation. We did not move on anything dealing with a departure from the standard of care. Our motion was limited to...
No causation issue here, because if in fact he was aware that there were metastases and malignancy and didn't communicate that to anyone.
Your Honor, I respectfully urge the court that...
Excuse me. The issue that raises is if he had communicated that, then Mr. Greenspan could have undertaken various kinds of therapy which would have limited the effects of the metastases so that his spine wouldn't have been as weakened as it was in February. So it seems to me that that does relate to causation. Could you address that, please?
Yes, I will, Your Honor. First of all, the moving defendants that are appellants had experts that were very clear on what happened here. There was a hypertensive episode during an MRI that was done where there was a clear plan to discharge a patient and perform hormonal therapy. That we moved on to lack of causation because the immediately effective cause of this patient's paralysis is not related to the alleged failure to diagnose the cancer. And the opposing expert, Your Honor...
So if the tumors had not been so widespread in February, then the mechanism by which the scan was performed would not have caused the same damage. So it seems to me that the causation is still very much in effect as to your client, because it was in part his failure to communicate the metastases and malignancy in January that caused Mr. Greenspan not to have any treatment at that time before the February incident.
And Your Honor, I respectfully urge the court that this court has found where experts come in with more of a solid opinion and rationale on what could have been done, that was not expressed here. The experts who came in never said what the treatment would be. They just generally, conclusively,
Well, you know, when you look at page 3413 of the record, which is a redacted affirmation from one of plaintiff's experts, this is what it says. However, I can state to a reasonable degree of medical certainty that the delay in diagnosing and ultimately treating Mr. Greenspan's spinal cord tumors was a substantial factor in causing cord compression, which directly led to his paraplegia. Mr. Greenspan's spinal cord was severely compounded by the long-standing issues of cord compression. Dr. Greenspan's letter of December 22nd, 2014, Dr. Goldenberg recognizes in that letter that the plaintiff is suffering from metastatic cancer. Don't you think that it would have been important to know what the source of that cancer was? So you have problems on two fronts, it seems to me, in seeking summary judgment. One, plaintiff's expert seems to clearly create an issue of fact as to the delay in diagnosing and treatment contributed to the paraplegia. That's what the expert on page 3413 provides. And then when you get to Dr. Goldenberg's letter at page 196 of the record, he's talking about all sorts of further tests that should be taken, but he doesn't mention a PSA. Wouldn't it have been important to know the source of the cancer?
Your Honor, this case has to have a focus on the effect of the MRI and the fact that the MRI in a general anesthesia was not ordered or participated in by Dr. Goldenberg. There are 4 levels here in which causation, the nexus is broken.
But what do you do with what plaintiff's expert says at 3413?
Your Honor, I say that that expert is speculative and conclusory. The expert does not identify what tumors, cervical, thoracic, or both could have been treated. There's just a general statement. What time are they going to treat this? So you got a 2-month period on a person with stage 4 metastatic prostate cancer who presents himself at that time. Well, what was the time of treatment? How would the tumors have been surgically excised when it's not even expressed by a surgeon, number one? And number two, during that whole hospitalization, there was never any consideration of doing surgery until after he was rendered paralyzed by a hypertensive episode that is clearly acknowledged by even the opposing experts. So the speculative nature of their opinions, in contrast to the moving appellants' opinions of their experts, renders this a clear lack of causation. I would respectfully refer the court to the Ventricelli case, which is the Court of Appeals case, 45 New York 2nd 950, where the Court of Appeals held in that case that dealt with a kidneys and a car incident. The immediately effective cause of the plaintiff's injuries was something that broke the causal nexus. And I respectfully refer the court that the immediately effective cause here
Thank you. You've passed your time.
is the MRI. Thank you.
Good afternoon. I'm Robert Devine. I represent Stand Up MRI in this case. First, I'd like to talk a little bit about the Ventricelli case, Your Honor, in answer to your question, because what we're talking about in a case where you're suing for a superseding intervening cause, the negligence of the moving party is not an issue. We are talking about cause. And in the Ventricelli case, the Court of Appeals said that because of convenience, because of public policy, because of a raw sense of justice, the court will not extend a series of events beyond a certain point. In other words,
Counsel, this is Justice Gesmer. I'm familiar with that case. I just don't see why that's relevant here. And your employee, Dr. Mark, said that he basically misread the report and failed to see evidence of a tumor on the sagittal TI that was suggestive of metastatic disease.
Yes,
so if he had not failed to do that, and in fact had made that clear to Mr. Greenspan, then Mr. Greenspan would have had options to do therapy that would have prevented
Yes, Your
Excuse me.
Honor, I
Excuse
agree.
me. Don't
I
interrupt.
agree.
Please
I-
don't interrupt, counsel. That would have
Yes,
prevented the unfortunate
yes.
occurrences because it wouldn't have occurred. So I have difficulty seeing why the eventual paralysis was not, in fact, in part, a result of your
Yes.
client employee's failure to identify the metastases back in October of
Yes,
2014.
okay. Judge, if you read the Santiago case that this court ruled on, I can explain that to you. It was a case where some work was done in an apartment, and there was conceitedly negligence on the part of the construction people in leaving a lot of debris around. The grandmother who lived there said to her granddaughter, I put everything in a bag, take this outside. She did not tell her, however, that there were dangerous materials in there. The court said that it's obvious that the defendants were negligent. However, no reasonable jury would foresee that the grandmother wouldn't warn her daughter, be careful, you can get cut. And that's what happened.
That's a very interesting case, but I don't see that it has any deep relevance to this case. Here, the fact that your client's employee did not give Mr. Greenspan notice that he had metastatic cancer caused the cancer to continue to develop and resulted in, among other things,
Yes.
that he treated in a, excuse me, that he was treated in a way that led to paralysis. That could have been foreseen because the greater development of the tumors meant that he could not tolerate certain kinds of the decrease in blood pressure that would have otherwise been tolerable. I don't see as, excuse me,
Yes,
I don't see that that is binding or even relevant on this case.
Judge, if you read the cases where the plaintiff lost and a defendant who was concededly negligent won, you will see that every person or party who won on a case moving for superseding intervening cause,
But counsel,
negligence.
I'm sorry.
Negligence was not an issue.
There are two components here. Oh, sir, I have a question.
Oh, I'm sorry. Judge, I'm having a little hard time.
I'm sorry.
Yes.
There are two components to establishing a superseding intervening situation. You need a lack of foreseeability, and you need a clear break in the nexus, like no nexus between what took place in relation to the negligence. You agree with that, sir?
A break. Well, what we need is something that's unforeseeable.
Right. I just said that. You need something that's unforeseen, and you need a lack of nexus, linkage between
Yes, Your Honor.
the event that took place in February here,
Yes.
paralysis,
Yes.
that your expert attributes solely to the hypotension as a result of being under anesthesia for the 100 and some odd minutes. And that led to the lack of perfusion, the lack of blood supply to the spine that created the infarct. That's your position.
Yeah.
Am I correct? So the point here that my colleague was raising is that by Dr. Mark failing to pick up on the tumors in the spine in October of 2014 and being able to communicate that to the plaintiff would have had therapy, so could have possibly vitiated or made the need for the MRI under anesthesia in February unnecessary because he would have been treated and the tumors would have shrunk. But because the tumors were there and could possibly have weakened the spine and compromised it, that is a cause, a contributing cause, together with the low blood pressure in causing the paralysis. So that the nexus is not necessarily broken. And if the nexus is not necessarily broken, then we would not have a superseding event that would break the causal link. Do you
Well,
hear what I'm saying?
To be honest with you, Judge, I'm not getting everything. Between my hearing aids and the mask, I'm not getting everything. If I could answer your question that I think that you're asking, if Mr. Greenspan is up in his room and has been told that the plan of treatment is to take a biopsy, which they did, wait for the results to confirm that he has metastatic prostate cancer, which is what he was waiting for, and then he would be discharged, and somebody comes up to him and says, you're going to have an MRI under anesthesia, and he goes downstairs, could he foresee that they would put him in a room where he would have the MRI and the anesthesiologist would be in another room and could not see what the vital signs of the patient were over more than an hour? Why? Because he doesn't want any radiation. The hospital's expert, Dr. Brusco, explained it very well, that the anesthesiologist is outside the room, but there's a tube going from the anesthesiologist that could be 6 feet to 20 feet long if he needed to give the man some medication. The anesthesiologist made no entry onto the graph showing the vital signs. He gave the man propofol because he had high blood pressure and then left. During the course of the anesthesia for the MRI, the patient developed low blood pressure, hypoperfusion that lasted over an hour. He had walked into the MRI machine. When he woke up after the anesthesia, he's paralyzed from the waist down. The record, if you look at page 403, there's an entry that during the course of that procedure, the patient complained of inability to feel his legs and also had no sensation below his chest. If you look at the picture of the patient in that MRI machine at page 508, his chin is on his chest. He's down like this. They're compressing him in this tube. When he wakes up, he's paralyzed. Something happened. There's no dispute about it.
Thank you. Thank you. Thank you. You're past your time. Your time is finished.
Okay. Yeah. Oh, my time's up. I'm sorry. Thank you very much.
Thank you.
Good afternoon. May it please the court. My name is Heidelin Semick with Fury Leverage and Darlington PC, counsel for the appellant Ron Mark, MD. Mr. Devine, counsel for Stand-Up MRI, has covered my positions cogently and expertly. I don't want to repeat Mr. Devine's argument, so unless the court has questions for me, I will rely on my brief.
Thank you.
Thank you.
Good afternoon, Deirdre Tracy from Aronson Rappaport, Feinstein and Deutsch. For the appellant, Dr. Pinavet, and the appellant respondent, NYU Hospital Center. What we know here is that in early October, the plaintiff, having suffered from right arm and shoulder pain, underwent an MRI. Dr. Mark, in his deposition, acknowledged that that MRI showed evidence of spinal tumors, but didn't report it. So we have from the beginning of October through the next month and a half, the plaintiff seeking treatment for what he believes to be, and other doctors believe to be, an orthopedic condition. Then on November 18th, orthopedist Dr. Capacey refers him to Dr. Pignavat to have this right arm issue evaluated in an emergent fashion. 2 days later, plaintiff appears to Dr. Pignavat, a primary care physician, to have the right arm situation evaluated. Dr. Pignavat, as a primary care physician dealing with an acute visit, met his duty of care, which Dr. Bardis explains in support of our motion. When he evaluated the plaintiff, asking him a history, there was no history or symptoms of lower urinary symptoms or any blood. It was all about the arm. He ordered the appropriate testing. The same is true on the next visit on 11/26, when they were waiting for him to get the CT scan of the right upper extremity. Upon getting the results of the right upper extremity, Dr. Pignavat, as the primary care physician, promptly called the plaintiff. There was some telephone exchanges because there was a voicemail, and he recognized the concerning presence of the ground glass nodules. As a result, again, as a primary care physician, he sent him for a further workup in order to see what that meant. As a primary care physician, he's not diagnosing cancer, and as Dr. Bardis explained, it was not the standard of care in 2014, without any symptomology, when a patient is showing up for an acute visit, for Dr. Pignavat to have performed a PSA or a digital rectal exam. Upon receiving the results of the December 8th CT scan, Dr. Pignavat, again, as a primary care physician, promptly referred the plaintiff to the oncologist. So it's our position that he met his standard of care and that nothing he did or didn't do caused the plaintiff's injuries.
And counsel, he in fact advised plaintiff that he believed that there were metastatic lesions at that time, correct?
Yes. So turning
regardless of whether he should or shouldn't have sent him for a PSA,
it was
Dr. Pignavat pretty quickly comes to recognize that the plaintiff is suffering from metastatic cancer.
Yes, it was concerning for metastatic cancer based on what he saw. Turning to NYU. So the substantive issue as to NYU is quite narrow now. The procedural way it came to pass is a little more convoluted. So what we have here is that this is a previously unpled theory of liability where the co-defendants on summary judgment, when no one pled the affirmative defense of superseding intervening cause, and no one sought any discovery in any way, shape, or form on anesthesia, advanced this theory of liability on, this defense in defense of their summary judgment motion. And I'd like to just turn to the substance first to explain why that defense doesn't hold water. But I won't go into too much detail because I want to address why we should be awarded summary judgment as well. But as you noted, their two experts, and this is what we discussed in our brief, did not in any way, shape, or form discuss the factual and the facts over the several months leading up to the unfortunate event of February 25th. So they never could have met the standards, the legal standards, showing that all of those events were suddenly superseded by what happened on February 25th. With respect to what the experts said, and this goes to the next argument with plaintiff moving to amend their bill of particulars, plaintiff made that motion relying solely on the co-defendant's experts, and those experts never identified a departure.
Putting aside the superseding issue, who's responsible for the fact that the MAP maintained during the MRI seems to have been too low?
Well, the anesthesiologist is responsible for that, but I would like to point out that there's a little dispute.
He's your responsibility, right?
Yes, correct. But I would like to point out that the only expert who actually discussed the MAP in any detail was our expert, Dr. Brusco, who was offered in opposition.
Dr. Brusco says at page 3382 of the record, thus of hyperfusion during the performance of the MRI caused or contributed to spinal cord ischemia or infarct, it was an unpreventable consequence of the need for a spinal MRI in this patient. Isn't it a little bit hard to accept the idea that a patient goes in from an MRI and he comes out a paraplegic and it's an unavoidable result?
Well-
Especially when you've given there is the explanation that the MAP was maintained at too low a number.
Well, it is an unfortunate, no one is denying that something happened and it's a very unfortunate event that happened. The dispute here is what actually caused it. And even plaintiff's own expert equivocates. It could just have been, well as been from positioning. What everyone is, besides the co-defendants, is in agreement upon is that it was because the spinal cord was so severely compromised, and all of the experts, our experts and plaintiff's experts also say that the prior imaging could not have informed of all the mechanisms and the lesions in the spine, which was why the MRI was actually necessary. But I would like to go back to the
But
anesthesia.
before you get off of that, counsel, I think that the other important issue that I think you're sort of alighting over is whether, even if this was an MAP that might have been appropriate on a healthy spine, with an unhealthy spine as there was here, it appears that it was too low an MAP and had disastrous effects. I don't understand why that doesn't create a question of fact that has to go to a jury about how exactly what the mechanism was of that occurring.
Well, I would like to just point out just how plaintiff's expert anesthesiologist says, it is my opinion to a reasonable degree of medical certainty that there is not enough evidence in the medical record to prove or disprove that the anesthesia played a role in his paraplegia. He then also, or the expert then goes on to also say that it appears the systolic, and this is on 3437, the systolic blood pressure was between 55 and 65, and then also says that sorry, I'm looking for the map. So essentially what he then goes on to say is that the departure would have been, if they had known how severely compromised the spine was, allowing the blood pressure to remain at 80/50 for more than an hour. But that's inconsistent with his opinion and also with Dr. Brusco's detailed explication of what the actual blood pressures were throughout this scenario. We only have certain select incidences where the blood pressure reported was actually as low as they're saying it needed to be in order to cause this problem. And that's on 3282. Dr. Brusco says the MAP ranged anywhere between 55 and 108. So it was only episodically as low as all of these experts are saying that it needed to be this low for a prolonged period of time. While anesthesia as a total was over an hour, that MAP or that systolic blood pressure.
Doesn't Dr. Bryson's affirmation keep NYU in the case no matter what?
Dr. Bryson's?
Yeah, for Dr. Goldenberg's expert.
No, I don't believe it does so, because he doesn't talk about the standard of care, and he too doesn't explain what exactly the MAP was in this case, other than really making a conclusory.
Well, he says the mean arterial pressure is the average pressure in a patient's arteries during one cardiac cycle. He does explain it, doesn't he?
Well, and he goes on to say a fall in the blood pressure readings during a procedure for a significant period of time can result in a drop. And he talks about that drop being at or below 60, which is what we're saying with Dr. Brusco. He explains how that was never it was never below 60 for a prolonged period of time, nor was the systolic blood pressure below 80 for a prolonged period of time. It was episodically at those levels, which was just on a continuum. Unless anyone has any questions, I would just respectfully request that the order be reversed insofar as it denied summary judgment for Dr. Pignavat and NYU.
Good afternoon, Your Honors. Brian Isaac, I represent the plaintiff respondent. Let me try to do it this way because there are a lot of people and I don't want to go over my time. We have two separate threads of malpractice. The first malpractice, as the court has explained, is the failure to diagnose a cancer that was plainly evident based on Dr. Marks's admission in October of 2014 and wasn't actually conclusively diagnosed till this unfortunate plaintiff went into the hospital in February of 2015 with a PSA of 2,000. That is astronomically high. The evidence, there is abundant evidence from abundant witnesses to the effect that the cancer developed over time, weakened the spine, caused instability, and created a cord compression, which had to be dealt with and ultimately led to paraplegia. Second line of cases. This is by the defendants against the defendants. The methodology by which the MRI was conducted at NYU on the 25th was so bad, was so terrible, was so horrible, that it constituted a superseding cause.
Counsel, can I just ask you a question? As to Dr. Pinavet, the indicators that he reported that he failed to report, no excessive urination, no issues with bowels or anything of that nature, that would have indicated prostate cancer. How should we view that in light of any liability towards that doctor?
Well, I think what the court was basing it on and what the experts were basing it on, Justice Pitt, is pages 1397 to 1399 of the record. I'm just trying to give you the pages because I know it's a gigantic record and it's hard to see. And here's the operative quote, and if I can just give it to you, if it's okay with you, I'll just read it, it's just faster. Question, this is on line 13. Did Dr. Goldenberg ever have a discussion with you about cancer? Answer, no, other than the first visit saying he didn't sense a malignancy, but no, we never discussed cancer. Question, prior to your diagnosis at NYU, had anyone else discussed cancer with you at that point? Answer, it's an interesting answer. Actually, I actually brought it up one time to Dr. Pinavet. That's the doctor you're talking about. And I asked him, he called me one day and he said something about those nodules, and he said he was going to check further, and he was asking me if I ever had pneumonia, and I told him, yes, I did. And he said, okay, we're going to check into it. It could be an old injury that you had. And at that point, I asked him, it's nothing serious. And he said, we're going to check it out. When did you have pneumonia? I had pneumonia while I was attending college upstate. So I think the position of the plaintiff's expert, if I can be fair, is given what this patient had, and given these test results, I mean, these test results are outrageous. In December, let me just go in order. The CAT scan that Pinavet ordered on November 25, 2014 revealed, quote, right lung abnormalities consisting of several ground glass nodules, and ground glass nodules are indicative of metastases. That's on 593. Chest x-ray at NYU was, quote, worrisome for pleural metastatic disease, close quote, and showed, quote, multiple areas of vertebral body sclerosis suggesting metastatic disease. Still, nothing's done.
Wasn't there a referral to Dr. Goldenberg?
Yes, there was. And here's my argument on that. And I would ask you to look at McNulty, and I'd ask you to look at a case called Runny against Nolan, cited in our brief. The fact that another doctor was negligent doesn't extinguish another doctor's negligence, even in a situation where the secondary doctor could have taken steps that would have ameliorated the injuries completely. And here's why. My adversaries are very smart. They write really good briefs, but I just think they're wrong on the medicine, and I think they're wrong on the law. Judge Friedman, can I just go on? I'm sorry.
Go ahead.
Okay. And it goes back to Toth against Community Hospital. Here's the argument. You don't treat specialties. You treat people. If I'm being treated by 7 doctors and they refer everyone to a super specialist, if I'm not getting treated for something that's obvious, somebody should call me up and say, hey, Mr. Isaac, you have a potential problem, it's not being treated. It's not a question of whether they made an acceptable referral. It's not a question of whether Dr. Goldenberg was a good doctor. He is a good doctor. They're all good doctors. They didn't want to do anything wrong. They made a mistake. But you have to look at the patient holistically, and this patient had preventable cancer. If you look at our experts' affidavit, they even tell you how it would have been treated, very simply, radiologically, hormonally, and they would have excised these tumors. They wouldn't have had to take an MRI, and they certainly wouldn't have had to take an MRI under anesthesia.
So the defendants seek to assert that the standard of care did not require that a PSA have been done on the plaintiff, but your expert, which certainly creates an issue of fact, says that there's no question that a person of his age should have had a PSA done.
Especially because it's a blood test. He was ordering tests anyway. You just test the blood. And he didn't have a prior history. He had indications of pain, sure. Look, I'm not suggesting to you that this is a 240 sub 1 labor law case, or is it a hit in the rear? I still have to prove the case, but this is a summary judgment motion. I can be completely defensive and win because it's the obligation of all of these fine lawyers to rule out my case as a matter of law. Not only didn't they do it, Your Honors, they didn't try to do it. They're fighting with each other. When the defendants fight with each other over who's responsible, the plaintiff should win. Thanks.
Thank you. Go ahead. 1 minute. 1 minute.
Yes, Your Honors, I don't want to repeat what I said before, but this is solely vis-a-vis my client, Dr. Goldenberg, the oncologist, a motion on causation. The treatment is not an issue, and I respectfully submit that the issue is that Dr. Goldenberg, the oncologist, could he have foreseen that there would have been an MRI done against the discharge plan, that the MRI would have been done under general anesthesia, and there would have been a hypotensive episode, and the hypotensive episode is what led to the paralysis. And I submit this was in a man, and this hasn't really been focused on, a man who was walking around for
Counsel, he could perhaps have foreseen that his failure to advise the patient that he had metastatic cancer would mean that the patient wouldn't get treated for it, and that would weaken him so that any future treatment would be much more dangerous than it would have been if he had been treated. Couldn't he have foreseen that?
Okay, Your Honor, in the issue of foreseeability, the issue is what was the immediately effective cause of this man's paralysis? A man who was walking around for 6 months, who was working up to 15-hour days up until the day he went into the hospital, and a few days later had the MRI under general anesthesia. Had he not had that MRI, he got up and walked into the scanner and was paralyzed in the scanner. And all the experts concede that there was a hypertensive episode that occurred, that the blood pressure was low. So the issue is what was the immediately effective cause? And I respectfully submit to the court, based upon the experts, anesthesiologists for the defense who have presented, that it was clearly the hypertensive episode based upon the facts, and the fact that he underwent a pelvic biopsy and nothing happened there, the map was up.
Thank you. Thank you, counsel.
The one thing is that the opposing experts did not outline what treatment when. 2 months. My doctor only was involved 2 months. When were they going to treat this? How was it going to be treated? Nobody said that. It's all speculative. It's all speculative and conclusory.
Thank you.
I respectfully submit that this man should never have been subjected to the risks of that procedure because of the treatment plan which was violated by the employees of New York University Hospital, so that if the cause was the procedure and the treatment plan was to treat him medically, they violated that plan when they subjected him to the risks of that procedure, whether it be positioning in the tube, whether it be by the hypoperfusion that developed. If Mr. Greenspan could not foresee what would happen to him, the way they were going to treat him, not being able to see his vital signs, in violation of the treatment plan of his oncologist and NYU, how could Dr. Mark, 4 months before that, have foreseen such an event?
Thank you.
Thank you very much.
Thank you.
I won't take too much time. Just one quick point with Dr. Pignavat. Plaintiff's counsel represented that he should have treated plaintiff holistically, and yet that's what he actually did. While it may have been over the course of 3 visits, what we go back to is on that first visit.
You also represent NYU.
Correct.
So I don't know why you don't think that Dr. Bryson's affirmation creates a problem for you. He says at page 175, a map at or below 60 causes vital organs in the body to be deprived of the nourishment they need for survival and can lead to shock and eventually death of cells and organ systems. And then he goes on to conclude, the map in this patient was at or below 60 mm of mercury throughout the total spine MRI, which is a hypotensive and ischemic event resulting in the plaintiff's inability to use his lower extremities.
Well, this was what I was trying to explain before. Perhaps I wasn't clear, but he's just making a conclusion statement. When you look at Dr. Brusco's affidavit, which I believe is 3382, and he talks about the map, it wasn't at or below that number for an extended duration. These dips in those levels were only episodic. They were only dips. It was not for the entire hour or hour and 20 minutes, I believe it was, that the patient was under anesthesia.
So Dr. Bresco says it's inevitable, but it would seem from Dr. Bryson that had they maintained a higher MAP, it wouldn't have been inevitable.
Well, perhaps if they had maintained a higher MAP. However, you're talking about what the standard of care is based on the facts as NYU knew at the time, which is why everyone points to the next day after they had the results of the MRI, when the MAP was maintained a little higher. It was maintained at 90. So before the MRI, which plaintiff's expert, our expert Dr. Johnson, our expert Dr. Bookvar, and our expert Dr. Brusco all agree that the prior CT scans never gave the more intense information that would have led anyone to believe that they needed to have the MAP maintained at 90, which they then knew the next day based off of the MRI and his unfortunate injury.
Thank you all.
Okay, thank you very much, Eric. The next case for argument is Cookies on Fulton versus Aspen Realty.
Could I ask Your Honors to clarify the timing, please, for us?
Well, it says 6 and 2 and 5 and 1, so you get 6 and 2.
Okay, thank you. May it please the Court, David Jacobson for Appellant Respondent Cookies. This is an insurance coverage dispute about how broadly an exclusion for construction and renovation activities should be read to apply where those terms are undefined in the policy. A worker sued Cookies, a department store, claiming he was injured changing light bulbs and fixtures. Yes.
Does the volume of the work make it renovation? In other words, there was like 20 lights on the 2 floors and some other work that was done. And it was done over a period of days. So does that make it more renovation and less maintenance?
No, Your Honor. Our view is that the number of lights that were changed or not changed is irrelevant. It's the purpose of the work, which was to replace light bulbs that weren't working properly and light fixtures that were no longer working properly. And by the way, there were actually, according to the testimony of Cookies' owner, which is clear, there could have been as many as 50 lights in a lot of these rooms. And the evidence does not support that like all 50 lights were replaced in every room, and Aspen concedes that not all of the lights were replaced.
And the invoice describes it as electric maintenance, correct?
That's correct. Yes, that was the Besson invoice. That was generated contemporaneously.
Right.
And that's the third-party firm that does this work, and that's how it was described, and they did this work from time to time. So to prevail, the insurer, respondent, appellant Aspen, would need to meet its burden of proving that the work was unambiguously construction or renovation under the terms of its exclusion, and not maintenance-related work, which is the exception to the exclusion. Aspen can't do that because on these facts, that's not unambiguous. Summary judgment should therefore be granted in favor of the insured. Fact discovery occurred in the underlying action, including depositions of the worker and of Cookies' owner. The focus of the underlying action is whether this worker fell and was injured and Cookies was negligent. The deposition testimony in the underlying action discussed work performed, but the focus of that case is not whether work was construction, renovation, or maintenance under the terms of this exclusion. That's the issue here. Fact discovery in that case is closed, as it is here. Aspen took limited discovery in this action, did not take any depositions. A note of issue was filed, and both parties moved for summary judgment. Both parties acknowledge that all of the material facts have been developed, and the question is now how the exclusion is interpreted as a matter of law that the court must decide. The trial court determined that the work was not construction. However, the trial court stated that it couldn't determine whether this work, quote, crossed the line into renovation. That's at record.
What was the testimony that the judge considered to determine that it could potentially be renovation?
That's not specified in the record.
I mean, because you had an oral argument before her, right?
An oral argument. She did not clarify exactly what the fact issue was that she thought was required any, denying summary judgment.
So did anybody that testified, you said the depositions are finished, did anybody testify that renovation work was going on here?
No.
Because I didn't see that in the record. I wasn't sure if I missed it.
No, that's not in the record, Your Honor.
So the judge determined that, but you're not sure what she based her determination on?
The judge didn't determine that there was evidence supporting renovation.
She thought that it wasn't clear that there wasn't renovation.
That's correct. And based on that determination, because she can't find it unambiguous that there was renovation, the law requires finding that Aspen has not met its burden. Yeah, the work was not unambiguously renovation. It was replacing bulbs and fixtures in store stock rooms. They were being replaced because they'd gone out or dim. The owner of Cookies called Besson, a vendor that does this work from time to time, and Besson sent workers to the store to replace lights and take care of other assorted tasks that needed attention, like changing out a switch. There was no formal scope of work document here. This is an informal call to take care of an issue, dim stock rooms. There were no new types of bulbs or fixtures installed. It was just replacing bulbs and fixtures with the exact same types of bulbs and fixtures. No fixtures were put in new locations. This wasn't done to upgrade the space. It was simply to keep it in its normal working condition so that the space could be used. That's maintenance and not renovation. And the legal point here is critical. It's Aspen's burden to prove that the work was unambiguously renovation, and Aspen can't prove that. Even if tons of lights were changed, at best there would be maybe a question as to this work definitionally could be classified as renovation or maintenance. And if that's the question, Aspen has failed to meet its burden of proving that the exclusion that it drafted unambiguously applies. Aspen wants to stretch undefined terms in its policy to reach a situation that those words, according to ordinary usage, do not clearly reach. If Aspen had wanted to cover this type of work, it could have drafted the exclusion differently or more clearly so that it could have applied, but it didn't do that.
Counsel, is there an issue of fact created by the fact that the underlying plaintiff, Mr. Brokamoff, said that he was an electrician de facto, even if he hadn't been trained as one? And then, of course, Mr. Bessonov says, no, he was just a helper. But is there an issue of fact? I mean, does one draw the inference that this was renovation because Brokamoff did work as a de facto electrician?
I don't know exactly what de facto electrician means. The record is fairly clear on what his training was, which was essentially none. He was
Meaning someone who's not licensed but does electrical work. I'll use that definition. How about that?
Yeah, so no, I don't think so. I mean, there was some, the electrical work that was done here is described. It was basically like swapping out some fixtures, which involves unscrewing some things and then unplugging some wires and plugging some things back in. No new rewiring. Brokamoff did not have training on anything like that. He was there as a secondary person helping out. So no, I don't think that issue is pertinent to the disposition of this.
Okay, counsel, you'll have 2 minutes for a rebuttal. We'll hear from the respondent.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. My name is Adam Durst, appearing on behalf of Aspen Specialty Insurance Company. Despite what even the briefing might suggest or counsel's argument, the question before the court is actually quite simple. Does the work out of which the underlying plaintiff's injuries arose, which required the insured to hire an independent contractor, required multiple laborers over multiple days, including the replacement of light fixtures at premises with brand new fixtures?
So what else were they doing other than replacing light fixtures?
Well, they were replacing light fixtures over the course of 5 separate days.
So there were a lot of lights. That still doesn't make it renovation or construction.
Well, these are replacements of a fixture to the premises. This court has actually already determined that that type of work is construction work.
Where have we determined that?
That would be in the context of labor law and the industrial code, in which the industrial
Were there
code,
any, the invoice indicated maintenance, right? There were no light switches, wires that were changed? Why isn't this just general upkeep?
The invoice unilaterally indicated that it's electric maintenance, but that can't dictate what the actual work that was performed and what it's categorized to be. It's his unilateral characterization of it. If that were to dictate what the scope of coverage was here, you probably wouldn't see a contract in New York that labeled something construction or other term that falls within the labor law. It just can't be the case.
But whose testimony can we rely upon to consider that maybe this was, I mean, the judge already found it wasn't construction, but to determine that in fact it was construction or that possibly it was renovation? I mean, whose testimony supports that?
It would be the individual that was doing the work. And that's
He said he was just he said he wasn't a licensed electrician. He said that a few times. He was just doing some stuff for the company, and he could replace light bulbs and change some wires. How is that construction? I didn't see anything he said that sounded to me like construction or renovation. We see a lot of those cases here.
Sure. He provides about 20 pages worth of testimony in his second deposition as to exactly the work that was being performed. It provides a step-by-step analysis of the work being performed from start to finish as to the alteration or changing of a light fixture. Taking that together with the entirety of the project, which spanned 4 days, multiple laborers, 5 days and multiple laborers to complete, the project as an entirety is a construction and or renovation project. And because his injuries arose out of the work being engaged during the course of that project.
Do you think in its common parlance, changing light bulbs or changing a fixture would be regarded as construction or renovation?
Absolutely. The common parlance here, construction or renovation being defined as to place the property into a good state of repair, as opposed to maintenance, which is to maintain it in the existing state.
If there's ambiguity on who does that fall?
I'm sorry, can you?
If there's ambiguity, who suffers from the ambiguity?
Your Honor, I don't feel that ambiguity exists here. I feel that the work squarely fits within one of those definitions and not within the other, because here, the lighting at the stock rooms at the premises generally, and the lights themselves specifically, were not maintained in the existing state of repair. They were removed and replaced. And that, as this court has determined in the context of labor law, the risk that the insured is actually seeking coverage for in this context is construction work and or renovation work under New York law.
I'm a little confused. When you use the term fixture, let's assume the fixture in the back of the courtroom.
Certainly.
You know, you remove that and put in a new fixture. But my understanding of the record here is that they had to replace ballast, which is a component of the fluorescent light. It's not a fixture. The ballast has wires, so you, based on the testimony of your own client, whether he did it or the main guy did it and he helped, but you unscrew, you take the existing wire, you put the new ballast in. That's kind of, I would look at it like an energy source, so to speak, that energizes or electrifies, so that when you put the fluorescent bulb at the two ends, they light up.
Yeah.
So it's clear they were replacing bulbs that were out. Moreover, the cookies actually had a supply of these products that they maintained at their store.
If I may respond.
So I just want to finish my point.
Sure.
So when you keep saying fixtures as construction, it's confusing because I didn't see anywhere where they replace fixtures. What I saw is replacing bulbs and replacing ballast inside these fluorescent light fixtures as two-man teams, $400 each, $800 a day over a certain period of time, and you put great weight on the amount of laborers involved and the amount of money spent, and you and I know that has absolutely no relevance to the actual, what means construction, because you could have 100 guys changing one light bulb in the proverbial joke. So can you answer that part?
Absolutely. Respectfully, Your Honor, there's actually no evidence in the record that only individual ballasts were being changed on the light fixtures. If I'll refer you to pages 8 and 9 of our brief, our initial brief, where it describes the 6-step process and what he's doing during his second deposition testimony, and you'll see the specific record citations there. He's describing what's being replaced as boxes. And there's very specific testimony as to what the box that they're referring to is in the picture in the record. There's a black box. The black box in the record is the ballast.
Right.
The box that he is actually referring to, and this is something actually the insured's counsel, who represents the insureds in the underlying action, got out of the underlying plaintiff, that what he's actually referring to is the entirety of the box. And I can refer you to footnote 3 on page 8 of our brief, which references pages 366, 367, and 401 of the record to clarify your concerns.
Okay, thank you. We'll hear from counsel with any rebuttal, and then we'll hear from you on any rebuttal, since you both moved.
So I would refer the court to page 613 of the record. This is an affidavit submitted by Ivan Besanoff, who is the owner of Besson Electric. In paragraph 8, he says, if the bulb is completely out, it could just be the bulb that needs replacing. If the bulb is out, we check the ballast, which is a box inside the fixture, which regulates the heat and voltage to the bulb. Ballasts often go bad after a few years. Changing the ballast actually requires more work than changing the whole fixture because it involves more wiring. So we also use existing wires in the ceiling when we change the ballast, but it still takes longer. Even changing the ballast is more complicated. And so his testimony is that fixtures were getting swapped out here, but it was just because it was an easier procedure than dealing with the ballast. To the extent that Aspen is trying to say that this is like, construction or renovation because outside definitions ought to apply, like the labor law, it's the common usage that applies, and there's very clear authority on this point in the briefing, including, I believe, the Mostov case, and I can refer you to the page site, but it's in our reply brief. I rest, Your Honors.
Okay, thank you, counsel. You have a minute for rebuttal.
Your Honors, if you review carefully the affidavit that counsel references on 613 and 614, there's actually no reference from the individual testifying that that was what the work that was performed here. It's simply an anecdotal statement that he does not relate to the actual work being performed. In fact, the only testimony as to the actual work being performed came from the plaintiff himself. In that affidavit, all that individual did was merely instruct his clients to do whatever they needed to do to get the lights fixed. And I also respectfully assert there is actually no precedent that the plaintiff has stated that has clearly defined construction in any manner that would suit the goals that they are reaching in this. I couldn't hear exactly what case he referred to. I don't know about any case in the record. We've analyzed all of them. So if you have any questions, I'd be happy to answer them.
Okay, thank you. Thank you both.
Thank you.
People versus Sanders.
Good afternoon. Catherine Skolnick for Appellant William Sanders. This was a case riddled with unfairness at every turn and where the evidence that Mr. Sanders intended to retain the property by force was thin, no less. I want to turn to some of the legal errors in the case. First, Mr. Sanders was improperly allowed to represent himself, and the court in the process permitted him to make critical blunders that resulted in the admission of several pieces of critical and damning evidence. There were several reasons that the court's colloquy was deficient. First, the court didn't advise Mr. Sanders of his sentencing exposure, as the people conceded, and as this court has repeatedly required in Rodriguez and Jackson and Perry. The people offer no source for their supposed case-by-case rule as to this requirement. Second, the court wasn't specific about the dangers of self-representation, simply saying that it was a bad idea and generically spelling out some trial procedures.
Counsel, assuming that we were to agree with you that the proper search and inquiry wasn't conducted for the defendant to go pro se, why isn't this harmless error in light of the overwhelming evidence against him?
Well, initially, we don't believe that the evidence was overwhelming here. But first of all, it's not clear that harmless error applies. Under People versus Slaughter, there's some debate as to that. But even if it does, the error was not harmless here because the trespass notice was very damning. It was propensity evidence on the question of intent to steal, and the people relied on it liberally in their summation. They also relied on the physical evidence that was not suppressed as the result of Mr. Sanders representing himself during the suppression hearing. And that was the turnbuckle, the supposed piece of metal that he used, and also the property that he had, that he was accused of taking from the store. The court must assume that he would have prevailed at the suppression hearing and at the Molyneux hearing, which again led to the admission of the turnbuckle, the foot file, and the trespass notice. And I'd also note that Mr. Sanders was essentially—
Also, we have to make that assumption even though the defendant handed the turnbuckle and also the alleged broken petty wax thing that he had from the store to the cops. I mean, he gave them to them. So we still have to make that assumption that this would have been suppressed?
Under ward law, yes. But still, there was the issue of the Molyneux hearing that Mr. Sanders conducted as well. And notably, it was unfair for the court to suggest to him that the purpose for which he was essentially consenting to the trespass notice was a proper one. And while the court, certainly doesn't have the obligation to guide him as to strategy, it does have the obligation to conduct a searching inquiry to make sure that he can properly represent himself.
Wasn't there surveillance video footage in this case and an audio recording? So even if there were some errors in that, I mean, those other forms of evidence were quite strong in this case.
Well, two things about the surveillance footage. First of all, the people did not preserve the video from inside the store, despite Mr. Sanders' repeated requests that they do so. And we haven't seen it on appeal. That still remains to be seen.
The jury saw it.
The jury did see it, but we don't know exactly. There was some allegation that it did not match what was shown to the grand jury. There were potential inconsistencies that it exposed as to the complainant's testimony about whether Mr. Sanders had taken one or two items. And as to the 911 call that I believe Your Honor is referring to, again, this is, it shows Mr. Sanders certainly agitated, but he's also calling out and saying, sure, get the cops involved.
Did it show that the defendant had secreted something underneath his body on the wheelchair?
The surveillance footage?
Yeah.
I don't know. We haven't seen it. And it looked, the position that he took throughout was that he was using it to shop. He was using the wheelchair to store the items. And in fact, he was only one item was recovered, even though the store clerk, the security guard at the store who was undercover said that he had taken two. So there were issues with the evidence in this case. It was not as overwhelming as
Wasn't the explanation for that is that the store guard refused to take the item that he offered back?
the single item, but he said that Mr. Sanders had taken two items, and two items were not recovered from him. So there were problems, again, with the proof in this case. But regardless, Mr. Sanders was not did not knowingly waive his right to counsel in that he was not advised of his sentencing exposure. The court was not specific about the dangers. He immediately after the colloquy had a mental health-driven outburst, and the court didn't pause then and ask him, wait a second, is this something that we have to inquire into further? And again, there are several cases, recent cases out of this court saying that that sort of inquiry is required. So Mr. Sanders should receive a new trial here. Separately, he was potentially convicted of an uncharged offense because the court impermissibly broadened the theory of dangerous instrument to include not just the turnbuckle, but any item capable of causing serious physical injury, including the wheelchair. If the court has questions, I can address them on rebuttal.
Thank you. Thank you very much.
May it please the court, Andrew Seawald for the people. Good afternoon, Your Honors. First, about the pro se inquiry, counsel just said that the court was not very specific about the dangers that the defendant faced in representing himself. The court reviewed the defendant's extensive criminal justice history, including 4 felony convictions, 11 misdemeanor convictions. The defendant made clear himself that he had represented himself.
Did the court inform the defendant of his sentencing exposure? Was that something that was disclosed to him?
No, it was not, Justice.
Is that something that's required to be disclosed to him?
I submit that it's not. Notwithstanding this court's, some language in this court's decisions, Jackson, Perry, and Rodriguez, I would note that in all 3 of those cases, Jackson, Perry, and Rodriguez, this court discussed other factors that were that came into play in finding that those particular waivers were not valid. In Jackson, the court noted that that defendant had a history of mental illness, and the colloquy itself, that defendant seemed to not really understand what the court was saying when the court explained the pitfalls of representing himself. In Perry, there was some question about whether the defendant understood the nature of the charges. He said he did not understand them, and there was no inquiry from the court about that. And also, the court in that case, in Perry, did not warn the defendant about the pitfalls of self-representation, including mentioning any specific tasks. Here, in contrast, the court warned the defendant about having to write motions, having to question witnesses, having to deliver an opening statement, having to make legal arguments, all of these things, and made clear that all of these tasks would be extremely difficult for a non-lawyer. And in Rodriguez, that defendant, this court noted, had never before represented himself and had a 4th grade education and couldn't read English. So in all 3 of those cases, there were other factors at play, notwithstanding some language in the opinions suggesting that mention of the defendant's sentencing exposure may be necessary.
You don't think that I understand the factors you're trying to distinguish with the 3 cases you cited, but if someone decides to go pro se, the sentencing exposure that they're facing, you don't think that that's something that should be disclosed to them?
Of course it should be, but as the Court of Appeals has made clear, there are lots of things that should be discussed during a waiver of counsel inquiry, but the mere failure to discuss any one of those particular things doesn't necessarily invalidate the waiver.
And this issue of the overwhelming evidence, or maybe not overwhelming, how does that come into play?
Well, here the evidence was extremely overwhelming, and I would just, before I discuss that evidence, I just wanted to note that in 2 recent cases, the 4th Department, People versus Pinette and People versus Rogers, Pinette decided this year, that court, the 4th Department, said that a waiver was not invalid simply because the sentencing exposure was not discussed, and the Court of Appeals denied leave in both of those cases.
Dealing with the overwhelming evidence of guilt, if we don't agree with your outlook on the validity of the waiver, how do we deal certainly the video is an important part of that overwhelming evidence. How do we deal with the fact that it's not available to be seen on appeal?
Well, the record, there's ample evidence in the record about what was on the video. The video itself was not central to it didn't depict the events that happened outside of the Duane Reade, which is where the defendant pulled out the turnbuckle and wielded that turnbuckle. So the video didn't show those events anyway, but what the video did show was the defendant taking 2 items from the shelf, putting those underneath him in his wheelchair, putting down a soda or some beverage. And this is all from defense counsel's description of the video at trial. So the question on whether this missing exhibit is whether the defendant's entitled to reversal because of the missing exhibit, the question is whether there's a sufficient record, even without the exhibit, to resolve the issues that the defendant is raising on appeal. And here, the record is very clear from the defense counsel's own description during the trial about what exactly was on that surveillance video. And there's, the evidence was absolutely overwhelming that the defendant left the Duane Reade, that he pushed past the security guard and left the Duane Reade, but without going to the registers to pay for any items. He left with them, and then outside of the Duane Reade, he pulled out the turnbuckle when the security guards tried to stop him from leaving further. And then the police arrived and they recovered one of the items from him. They recovered the turnbuckle from him. So all of that evidence showed overwhelmingly that the defendant shoplifted and then used a dangerous instrument in order to try to retain the property when the security guards tried to stop him from shoplifting.
Thank you.
Thank you very much.
Counsel, we have 2 minutes for rebuttal.
So first of all, this court, not the Fourth Department, has held that an inquiry or an advisal of the sentencing exposure is required, and that just didn't happen here. In addition, in Jackson, this court said that a similar colloquy by this very same trial judge was deficient. And here we have some advisal or some warning that this is a difficult thing to do, but we don't have what this court has found required in cases like Perry, telling him that he has unfamiliarity with legal terms, concepts, the potential challenges of cross-examining witnesses and delivering an opening statement and summation. None of that happened here. And then I just want to turn again to the harmless error question. Assuming it even applies, I just want to review the evidence quickly. First of all, the people's version had some inconsistencies in it. The security guard in the store said that he saw Mr. Sanders take 2 items. He believed that he was concealing one and trying to give the other back, but he was he was stopped and only one was recovered. So there was that inconsistency. That he tried to give the sole item that was recovered from him back shows that he didn't have the intent to use force to retain the item when he was in the store. He was then approached by a man in plain clothes, dingy plain clothes, who didn't proffer an ID, and that person accosted him, and that's when he felt threatened and took out the turnbuckle. So even if he had the intent to steal the property initially, there was not overwhelming evidence that he had the intent to forcibly retain it, but rather that he was instead defending himself against what he saw as a threat from someone who basically came up to him in the Port Authority terminal without an ID. So for that reason, we ask the court to reverse the conviction. Thank you.
Thank you. Thank you both. El Rafael versus Solo. We just have one side here on this case.
Good afternoon, and may it please the court. I'm here alone today, but I wanted to emphasize to the court where this case is today and why we need the immediate entry of a judgment as we requested from Supreme Court. as the many motions we made to extend the time to perfect this appeal from a 2018 decision indicate, since the decision came down, Bergdorf Goodman filed for bankruptcy and is now out of the case. There was a stipulation to discontinuance. The two tenant plaintiffs, the El Rafael entities, filed a Chapter 7 proceeding, and they're not in the case anymore, nor do they even have an attorney pursuing claims for damages. So procedurally, the case exists solely, as this court recognized when it allowed me to proceed with this appeal, against the guarantor. So the issues that compelled Supreme Court to defer entry of judgment no longer exist, nor should we have any deduction from the guarantor's liability for the existing civil court judgment of $379,291.26, with appropriate interest from its entry date of June 18, 2018. Nor are there any issues of fact, really, substantive issues of fact to warrant denial of our request for the balance due of the agreed upon use and occupancy. That's another $93,038.09. What were the issues there? They made two payments without prejudice pursuant to court order. The lease provision said any payments of partial use and occupancy, which is agreed upon, would be on account. So there are no issues there. And then we come to the attorney's fees of $133,284.58. Now, Supreme Court found that the guarantor was liable for those fees, but didn't think we had enough proof. Well, we had an affidavit of services, my affirmation with the legal bills and the components, and all, in short, the proof that would normally go in a legal fee hearing. So that was not insufficient. And I think at this point, we should get that judgment too. And then the last thing is I moved for summary judgment as to the guarantor's liability for anything further. And I didn't get that. Judge thought I was asking for a declaratory judgment. It was clear I was looking for summary judgment as to liability. So at this point, I would suggest and hope that the court would allow entry of judgment for the relief I requested in the brief. Thank you.
Thank you, counsel. We'll certainly take a look at the papers based on what you've argued.
Thanks. Have a good day.
You too. Thank you. The next case is Mack versus Mack. We just have, again, one side here on that case. Okay, you may begin.
Okay, hello, Your Honors. I'm Barbara Masters. I am the pro se appellant. I used to formerly be Barbara Mack. Sorry. I want to begin by saying there is nothing in this case that has resulted in the best interest of our child, and that the lower court's actions were capricious, biased, premature, and my fundamental parental rights have been violated without evidence, without trial, and without any exigent circumstances. I want to highlight, most importantly, that this has all been done with a callous indifference to the damage that's causing our child. And I do want to speak to that, but in the interest of time, sorry, I would like to focus on two things. Give me a second, sorry. First, I want to address the elephant in the room. I know that it's been repeatedly alleged that I am mentally unstable and that I'm litigious, and that's why I would continue with this case, but that is not true. I am not mentally ill, and I am standing here because our child is being abused, and that this whole case has been an abuse both to my child and to myself. Secondly, what I want to, because there is limited time, address most importantly is that it is this court that needs to act urgently. It's clear that our child will age out, but that is not the only issue that is happening here. The lower court is ignoring the increasing damage that is occurring with our child. I want this court to be aware that since the AFC filed the child's brief, there is now a third ACS case that has been opened up against the plaintiff. My child ran away from him. She was then placed in foster care and then as staying with a friend, and presumably she is now back with her father, but nobody is telling me and nobody is giving me any information. When she was in foster care, no one contacted me. ACS refuses to speak with me. The lower court judge refuses to implement reunification strategies, and so does ACS, even though they are legally mandated to do so. I would also like to point out that nobody has spoken with me, and they placed her in foster care even though she has a loving older sister, she has loving family friends, and most importantly, she has a loving mother, so that even if she was refusing to return home to me, there was plenty of places that if they were speaking with me, we could have put her in a more appropriate surroundings. This is just the kind of violations of my parental rights that are occurring. But I do want to speak to the damage that is happening as well, because if the court does not rapidly act to make the decisions on the requests that I have that are more time sensitive, and instead returns it to the lower court, they're not going to be heard. The lower court judge has written an order denying an expedited trial since the filing of my brief. And he has also stated on the record that he does not intend to have his trial. So any statements and implications that a trial would resolve things is clearly not going to happen. In addition, he has refused reunification. So clearly the requests that are about efforts to put in place to allow me to participate in the mental health care decisions that would allow a reunification process to go forward must be answered here if they're going to be answered, not just because of her age, but because the lower court has made it clear that they are not going to act on that. I do want to also, since there is limited time, focus on my request that for the non-urgent issues that I would like to have considered, that this court please return it to a domestic violence court instead of to the Supreme Court. I am here pro se because I don't have any money. I have never been appointed a lawyer, even though I have asked, and to then have to conduct a trial in a Supreme Court is a clear disadvantage. I'm already clearly highly disadvantaged to begin with. If it's not going to return it to a domestic violence court, which is where this actually belongs, then I ask that it at least return it to the Brooklyn Family Court. All of us live in Brooklyn. I have no idea why it is in the Manhattan Supreme Court in the first place, but at least I would not be as disadvantaged.
Okay. Thank you for coming in and for highlighting those points, and we will certainly look at it further in your brief. Okay? Thank you so much. Have a nice day. The next case for argument is ATX versus Paul. You may proceed. Go ahead.
Good afternoon. May it please the court, Mitchell Shapiro for the appellant, Nathan Paul. We're here today on two interlocutory appeals, one that was perfected with respect to discovery denial order, another that was perfected with respect to the denial of cross motion to amend counterclaims. sounding in fraud, contract fraud pertaining to misrepresentations made on the bankruptcy court, in scuttling a reorganization plan of the borrowers, which are in total privity with the guarantor in this case. The lower court gave short shrift. While there are 350 documents actually filed on the NICEF below by Gibson Dunn and my firm over the past 2 years, the court itself actually spent very little time on this case. There were 2 oral arguments held and 2 discovery conferences held by the court's clerk. And unfortunately, the court got it wrong from the outset. As the court here will see.
Counsel, can I ask you a question?
Yes.
Bankruptcy was a triggering event, correct, for the guarantee?
A bankruptcy was one of the triggering events. We do believe that bankruptcy was forced by the lender that was then assigned. It was a predatory lender who then assigned the guarantee and the loan documents to a competitor of the borrower and a competitor of the guarantor, which hid his identity from the bankruptcy court, hid his identity from the guarantor and from the borrower, and opposed settlements proposed in the bankruptcy court, including...
If there was a triggering event, the reason I asked you that question was, why was then the plaintiff obligated, or the defendant obligated to allow the borrowers to figure out a way in bankruptcy to cure the default? Why couldn't they just go ahead and enforce the guarantee at that point?
Well, if there was a triggering event, it was a triggering event but not a default. There are 2 different things here, Your Honor. There's a triggering event under the guarantee, which means they have the right to now seek relief under the guarantee for any obligations owed. Mm-hmm. The question is, are there any obligations owed by the borrower to be collected from the guarantor who happens to be in privity with the borrower? There are no obligations here because there was no true indebtedness left after the rigged foreclosure sales that took place, which took all of these valuable Austin, Texas properties, which were worth far more than the indebtedness.
What did you submit to the court to support your allegations? Because I know I saw them many times in your papers about the rigged foreclosure sales.
Yes, Your Honor. So we were denied all discovery in this case. So all that we were left to submit to the court, which this court has held is adequate to defeat summary judgment and to support a counterclaim, was a 20-plus page affidavit of Nathan Paul, the guarantor, who was present at the foreclosure sales, who received the notices of foreclosure. The notices of foreclosure named 9 different substitute trustees for the 9 different properties, 9 of them for each of the properties, and then required that the winning bidder would have to come forward with a cashier's check payable to the appropriate substitute trustee, but you couldn't figure out in advance who it was. And when Mr. Paul's agents called up the lawyers, Liz Boydston of Polsonelli, who was representing the ATX2 and previously was representing Ladder, to find out who to make the checks payable to and how to bid on it. Because the court has to keep in mind, on May the 3rd, there was a debtor in possession financing offer made of $85 million for one of the pieces of property. The next day, ATX2 commenced a foreclosure sale on May the 4th, and at that foreclosure sale, ATX2 bid $90 million for that piece of property, and another bidder bid $90.5 million for that piece of property. ATX2 then had its substitute trustees say, okay, you have to be back to the courthouse within 1 hour with a cashier's check in the amount of $90,500,000 payable to this substitute trustee, this name. They came back an hour and 10 minutes later, and the agent said, sorry, foreclosure sale canceled. 1 month later, ATX2 rigged the foreclosure, so they took that same piece of property for $53 million, a discount of $38 million off of what ATX itself had bid the month before. That is exactly what courts have held, are overreaching, exploitative use of rigged foreclosures.
Now, these were obviously non-judicial foreclosure sales, right?
Correct. These were foreclosure sales, non-judicial, held on the courthouse steps by agents of the foreclosure.
Is this in Texas?
It is in Texas, and we asked the lower court to stay this action, given the fact that the guarantor is clearly in privity with the borrower, has the same defenses which he's entitled to raise because we've adduced proof in his affidavits, and
through the testimony of ATX's representative that was taken in the bankruptcy case, that the whole scheme was designed to put pressure on the guarantor to make him walk away, because he really is the controller, have him walk away from these crown jewel properties.
So
So we asked the lower court.
Wait. So the original loan was 47 million something?
Right, there are two sets of loans. In this case, there's a Southern District case
Well,
involving.
I don't care about them, but
Yes. The original loan was 47 some odd million dollars, Your Honor. $8 million worth of equity that was paid by my client. Another $47 million for the properties worth about $55 million. The balance on the loan was $44 million at the time that the foreclosure was called and the race to the courthouse started to stop the Wild West.
And were there any appraisals on this property done before these foreclosure sales?
Yes, Your Honor. There were appraisals done, and they were submitted both to the bankruptcy court and to the lower court as part of the judgment proceedings. And unfortunately, it seems like we're going to see this court again in September, October, if we live that long, and if my client's still in business by that time, because instead of granting summary judgment on liability only, as Gibson Dunn and ATX2 requested, and setting a hearing to determine whether or not there's duplicative recovery happening on the loan guarantee and the lease guarantee, when in fact there's evidence in the record that Liz Boydston from Polsinelli admits that the lease guarantees and the master lease assignments were merely another method of securing the same debt. Yet, Justice Barak below, when Gibson Dunn, when we complained about the double dipping that was going on and the duplicative recovery under this fictional lease guarantee, in footnote 2 of their summary judgment reply brief, Mr. Carlin and ATX2 said that, well, we're only seeking judgment on liability. We expect all of that to be worked out in an evidentiary hearing to determine whether or not there was the amount of any.
Yeah, I know that there's a judgment, because I'm sure you remember we all had a little application last week. Okay, listen, you've run out of your time, so let us hear from the other side. You'll have a few minutes to respond, okay?
Before my time starts to run, I don't know if you can see me clearly from this distance, but I apologize. I'm a little beat up. I'm hoping that the mask covers it, but I mean no disrespect by appearing a little bruised in front of the judges. So I'm hoping the mask is hiding you from.
Well, masks hide a lot of things, so I wouldn't worry about it.
Mitch Carlin from Gibson, Dunn and Crutcher for the ATX plaintiffs. Judge, this is a vivid Exhibit A about why lenders need absolute unconditional guarantees and why courts really need to enforce them strictly.
There's a carve-out in this waiver, though, correct?
I'm sorry, judges, I couldn't hear you.
I'm sorry, there's a carve-out in the waiver of defenses.
I actually don't agree with that, Judge.
What does the language mean, then?
Well, if we look at Article 2 holistically, Judge, I don't think there's any question that all the defenses that are being raised here are waived. For example, and this is just one example, in 214, which I know is the section that the appellant.
The things that are alleged by your adversary could not be interpreted to constitute willful misconduct under 2.14?
I'm having a little trouble hearing. They could not be.
The things that were alleged by your adversary.
Yes, Your Honor.
Why wouldn't they arguably be willful misconduct under 2.14?
Because they are allegations of misconduct against, as Justice Barak concluded, against the, in connection with the loans and not in connection with the guarantee. The ATX plaintiffs in this case have been named as defendants in the case that is pending in the state court in Texas, which the borrower, which is not Mr. Paul, the borrower sued the ATX parties immediately after the foreclosure.
Weren't the borrowers, or am I wrong, weren't they all companies that Mr. Paul is involved in?
The borrowers, Mr. Paul is the ultimate beneficial owner.
He's the guarantor, but was the owner of all these, of all the borrowers, right? He was.
As typically happens in commercial loans, Judge, the borrowers are shells, and the lender is unwilling to rely exclusively on the collateral, wants better security than that, and so asks for a guarantee. And the only person that's willing to give a guarantee in that circumstance is the ultimate beneficial owner.
But under the language of 2.14, even though it's things done against the borrower, isn't that what triggers the guarantee, and therefore it would fall within 2.14?
I'm thinking I'm hearing what you're saying, Judge. Let me see if I can answer it. If I haven't correctly heard your question, you'll tell me. What 214 says in the sentence immediately following the one that I know Your Honor is focusing your attention on, 214 says it is the unambiguous and unequivocal intention of guarantor that guarantor shall be obligated to pay the guaranteed obligations when due, notwithstanding any occurrence, circumstance, event, action, or omission whatsoever, whether contemplated or uncontemplated, and whether or not otherwise or particularly described herein, which obligation shall be deemed satisfied only upon full and final payment and satisfaction of the guaranteed obligations. Justice Borak, I believe, correctly read the guarantee as saying all of these defenses have been waived, and also correctly, I believe, read the guarantee or the affirmative defenses rather as being essentially pled against the lender and not against the party that holds the guarantee. We were not the lender under the original loans. If I could just pivot for 1 second to a slightly different subject, which I know you have not asked about, but which I want to make sure before my time runs out, I get to. As Justice Kapnick knows, there has been an event, a significant procedural event in this case since the briefing was completed, namely that there is now a final judgment in the action below. And there has been an appeal filed by Mr. Paul from the final judgment, which appeal I know is going to, if and when it's briefed here, is going to raise issues that are in addition to and different from the issues that are briefed and argued in the appeals that bring us here today. And I would ask the court to please consider whether under Chase Manhattan Bank versus Roberts and Roberts, 63 AD 2nd, 566, from this court in 1978, and I won't take this time to read the relevant language, whether under that case this court must dismiss this appeal. And if it's not dismissed, and we reach the merits on this appeal, I respectfully suggest that that is going to foreclose Mr. Paul from raising the issues that I know he wants to raise in connection with the appeal that he has already filed from the final judgment. It's a byproduct of the liberality with which New York procedure permits interlocutory appeals. We've got 3 appeals from one case, each one of which addresses more than one order below. But now that there's a final judgment, these appeals really cannot go forward, and if they are decided, it will foreclose Mr. Paul from raising issues that I know he wants to raise. I just want to raise one other point, and then unless your honors have questions for me. The allegations in the Texas complaint are absolutely identical to the allegations that Mr. Paul wished to present to Justice Borak. And in the record, you will find a motion that Mr. Paul brought to stay this action in front of Justice Borak, in which he argues that Justice Borak should stay this action because he says, and he's right, the allegations in the Texas complaint against my clients and the allegations in the affirmative defenses that Mr. Paul wishes to raise here, all seek to address the same harms, all seek to remedy the same harms. The guarantee is a separate document, it's a separate transaction, and it needs to be enforced without regard to what's going on with the loan or the foreclosure or the auction or the value of the collateral.
Okay.
Thank you, Your Honors.
Thank you. Thank you very much. Counsel, you have 2 minutes for rebuttal.
Thank you, Your Honor. Your Honors seized exactly on the points that we made below, at least in our briefs here. There is a carve-out. The carve-out is not just based upon fraud under the guarantee itself. Justice Barak seemed to remember the Plappinger case, which held that fraudulent inducement of a guarantor can be waived in the guarantee. But the other cases, Marino Overseas, Futterman, Ross, in this case, this court's opinion in Sterling National Bank versus Giannetti, all hold for the proposition that Plappinger only applies to fraudulent inducement waivers and not to post-closing waivers of fraud that occur post-closing directed to the detriment of the guarantor, which clearly...
So if I'm right procedurally, you had some affirmative defenses that Judge Barak dismissed, but you also wanted to add some additional affirmative defenses that focused on fraudulent activities similar to what you're alleging now, and he did not allow you to
Correct, Your Honor. Our answer was interposed before the rig foreclosure sales took place in Texas, and then we moved to amend to add 20 pages of detailed fraudulent
and you were not permitted
proceedings.
to do that.
Didn't give us an opportunity, and in fact said that even if he had given us an opportunity, that those affirmative defenses wouldn't pass muster because they didn't establish fraudulent inducement under the loan applications. That's not the law. Okay. The law directly backwards. The carve-out specifically says any other action taken or omitted to be taken with respect to the master lease, the loan documents, the guaranteed obligations, whether or not such action or omission prejudices guarantor or increases the likelihood the guarantor will be required to pay the guaranteed obligations pursuant to the terms hereof, except any act or omission constituting gross negligence or willful misconduct. There is no more willful misconduct than active fraud that sought to there was no remedies choice. There was a remedies choice here under the documents. ATX2 chose to go down both paths at the same time, to seize the valuable properties, to manufacture a false deficiency, which is exactly the case that the Southern District was talking about under New York law in the Ross opinion, and exactly the case that the Bankruptcy Court of the Southern District of New York was talking about under New York law in the Futterman case of 2019, where it says that a rigged foreclosure is something that cannot be waived by the guarantor. The law is clear, the facts are clear. Unfortunately, the court below was working very hard on many cases and did not properly apprehend what we were alleging.
Well,
did not properly apprehend what it is. And I would just want to say one more point about mootness, Your Honor.
Counselor, you're not giving me a lot of time.
But Mr. Carlin raised in his opposition the Hobson choice of being here today versus being here in October. And Your Honor is well aware that we sought a stipulation to supplement the record on these interlocutory appeals, to include the judgment and have it all heard at once. ATX2 denied that. They didn't want the court to see all the mistakes that were made with respect to the double dipping and the duplicative judgment. And we reserved our right to proceed here today without waiver of our right to proceed with the full appeal of the judgment that was improperly entered in the unlikely event that this court does not reverse the court below. And I thank you for your time.
Thank you. We will look the papers over again. Thank you both very much. And the last case for argument today is State of New York versus Warden. Justice Friedman is recused from this case. So in the event there is a tie, another judge will be vouched in. Whenever you're ready, counsel. Good afternoon.
Good afternoon. Thank you, Your Honors. May it please the court, my name is Arthur Idala of Idala, Bertuna, and Kamens, and I'm here on behalf of the appellant, Danielle Pacienza. Basically, Your Honors, the court abused her discretion when she found that the least restrictive means to ensure that my client would come back was by enforcing the most restrictive means. And this is on someone that had already had bail set upon them, a tremendously large amount of bail set upon them, and did return to court. And even before that, this is someone who surrendered moments, literally, after it was apparent to her.
Counsel, was there any further information between the time that the defendant appeared before Judge Gaffey and the time that she appeared in front of Judge Menon?
You mean
any further information about flight or any other pertinent information about setting bail or remanding?
There was information that was gleaned in the grand jury, but there was nothing that had to do with flight after she knew that she was wanted by law enforcement.
Would it be pertinent that the people, I think, made the offer to plea for 15 years on the May 10th appearance? And would that be something that would factor into or should it factor into a judge's determination about likelihood of return to court?
Based on Judge Menon's experience and knowing who the counsel was for my client, and the fact that there was weeks between the criminal court arraignment and the Supreme Court arraignment, I think a judge using her experience and common sense would understand that that client had come to our office several times and been told what she was facing, had been told that there's a major press case, that it's all over the papers, and that the first offer is going to be tremendously high, and there's a likelihood that there probably will be a jail disposition in this case because that is likely in all manslaughter cases. So with that knowledge that that individual had, not only did she return to court, she returned to court with her mother. She returned to court, and the judge, that's the one thing that the judge noted. She said, I do notice that she's here today. She also said, because you have to understand, Judge Moulton, her decision is like 2 paragraphs, so it's not a very expansive reasoning. She says she has access to significant amounts of bail. Now, obviously, you all know she doesn't have access to the bail. The bail was put up by her family, not by her. It was put up by her family, and she has no access to that bail. So that's one thing that she based her decision on that is absolutely an error, is absolutely wrong. She has no access to the bail.
I'm not sure that that's what she meant based on the whole transcript. You're talking about Judge Menon's decision.
Yes.
So, I mean, she had a fairly lengthy argument on the record, and I read it, but maybe I'm wrong, that she thought that your client had access to money that could be used for bail as opposed to the bail money. I think Judge Menon must have known that.
Okay, well, obviously she misspoke, but if you want to play that out, Your Honor, her mother was right in the courtroom.
Right.
So the judge easily could have said to John Leventhal, who put up the bail? Oh, her mother. Her mother's right here. She could have made an inquiry right there. Where did the money come from? Oh, it's your entire life savings? Oh, okay, and her grandparents' life savings? And the grandparents are on a payment plan to pay the legal fees to Idala, Bertuna, and Kamens? She didn't make any inquiry about the finances whatsoever. She also, the law says she is, the presumption, right, is that she's supposed to give the least restrictive to guarantee her return. She didn't explore any of those options.
Well, let me ask you something. I know when they went to Judge Bybin, Judge Mr. Leventhal spoke to Judge Bybin and offered a lot of different possibilities that had not been offered previously when they appeared before Judge Menon. Is that correct? And should that have been done? I mean, is this part of the reason that Judge Bybin found that Judge Menon didn't abuse her discretion based on what she had before her?
Judge Bybin seemed to focus more on the grand jury minutes because John Leventhal was reading from the grand jury minutes, and they said, well, Judge Menon didn't have the grand jury minutes, but the whole presentation by the prosecution was the grand jury minutes. He was just reading the grand jury minutes. But Judge Kapnick, it is the judge's obligation to select the most reasonable, the least restrictive. It's the judge's obligation to do that. Nowhere does it say that defense counsel has to enumerate every possibility. Mr. Esposito said, we'll bring her to court every...
Does the judge have to put on the record why she's not considering each least restrictive means, or can she select the one that she thinks is the least restrictive and apply that?
The law says that she's supposed to either put in writing or orally her reasons to find that this is the least restrictive means. Remand here, when there's already $500,000, it just defies logic. Manslaughter in the county of New York, there's always bail set on it. The only reason why bail wasn't set was because there were 3 rows of press. That's the only reason. This is not a case where I'm coming to this court from the initial criminal court arraignment where there was no bail. That judge trusted her to come back. And she put up the money, the family put up the money, and that trust was adhered to. And so that's the difference between what Judge Menon knew that the lower court judge didn't know. Will she come back? Now, here she is, she's back. The first time, Judge Pitt, she came to the courthouse with her father, knowing she's going to be charged with a homicide. She had 3 weeks to run. If she was going to run, she had time before the arrest to run, she had time after bail, and before the Supreme Court arraignment to run. She's not running anywhere. In their papers, they love to use the word she fled to Long Island. She fled to Long Island. She grew up in Long Island. Her parents live in Long Island. Her grandparents live in Long Island.
There was a 13-day or 12, 13-day time period between the time of the incident and the time that she voluntarily surrendered. And also in between that time, there was some testimony that her fiance had talked to her about this incident, so she was aware that maybe people were looking for her, and she still took 13 days?
Yes, she was aware that people were looking for her. She has the right to consult with counsel. Counsel is allowed to advise her. She has the right to remain silent. She's under no obligation to surrender herself when she's wanted. And however, she was in my office 2 days. They contacted me 2 days before. In my office, the day before the police came to her house. The police came to her house. She wasn't there. At 6 in the morning, by 7, I had negotiated with them she'd be in the next day. They had retained me 2 days earlier to surrender her Monday. I couldn't surrender on Sunday. I had nobody to call or to surrender her to. So her surrender was already in the books happening. I got on the phone with the detective while he was still at the house. I said, she's not there. Is it okay if I bring her in tomorrow? They said, no problem. Her parents brought her in there. In that period of time, between the first arraignment and the second arraignment, she was in our office many times, aware of all the facts of the case, aware of what came out in the grand jury, aware that she was indicted, aware that there was going to be a very heavy jail offer, and she walked, and aware that they were going to ask for an increase in bail when they went in front of Judge Menon, and she walked in with her mother. Her father took her one time, her mother took her the other time, and they were aware that any jail sentence that she gets, she can never run away from it, because in today's day and age, nobody gets away. No one skips bail. Everyone
Counsel, I think you should stop there.
Everyone gets caught, Judge.
How long? Sometimes it takes 30 years.
Okay. This young lady has nowhere in her mind that she's going anywhere. If she did, she had such ample opportunity to run. At $500,000 bail is her whole family's money. Her father digs ditches for a living, literally cesspool ditches. His income is under $150,000 a year. This is not a rich family. This is a family that has a big problem. They hired I would like to say, a very good law firm to fix the big problem, but they're not here to run away. If they did, she would have run away already.
Okay, let's hear from the people, and then you'll be able to respond. Thank you, Mr. Idella.
Good afternoon, Your Honors. May it please the court, Justin McNabney for the people. Your Honors, the habeas court below correctly denied and dismissed the writ because the bail court did not abuse its discretion in finding that remand is the least restrictive means of ensuring...
What changed? What changed?
2 things, Judge. As Justice Moulton pointed out, there was a 15-year offer. I respectfully disagree with my adversary that was to be expected. I think that that was certainly new information, and the grand jury had indicted her on the most serious violent felony that exists in the penal law, manslaughter in the first degree. The other change, Judge, is that the strength of the evidence increased substantially after the fiancé testified in the grand jury that she confessed to the crime to him, and her explanation for why she pushed this 87-year-old woman to her death was simply because she thought this woman might have said something to her, but she wasn't sure. There was no justification at all to this crime, and that confession confirms that. So we now have her indicted on an extraordinarily serious charge. We are recommending at the outset a 15-year sentence, and there is no defense that the people can see to these charges.
Well, I think there was argument before one of the judges I read in the transcripts as to whether or not she was intoxicated at the time of the incident, so that there may have been some question about whether she would have had the capability of forming the intent. And one of the judges said, well, you'll argue that on a motion when it comes up. So there are some issues that are going to come up. I'm wondering if the fact that she put up a very substantial amount of money, her family did, for the bail, and then came back with some of her family, would not be something that Judge Menon should have looked to, and why did she change the bail arrangement at that time? What was the length between Judge Gaffey and Judge Menon? Was that a month? Was it less?
Judge, I believe it was March 22nd to May 10th.
Okay. Thank you.
And Your Honor,
yes, I think that's right. I see that now.
And Your Honor, I would say there's certainly nothing in the record to suggest that Justice Menon didn't consider the fact that she came in with her family, or that she was there at Supreme Court arraignment. Certainly, Justice Menon did consider that. But I wanted to.
Was Justice Menon required to place on the record why she selected this form of a securing order, why she went to remand?
Yes, Judge. And I would submit that she did explain her reasons. She explained that given the severity of the charges, given the lengthy explication by the people of the evidence against the defendant, that there was a serious question in Justice Menon's mind whether she would actually return to court when the consequences were at hand. After a trial, this defendant faces up to 25 years. And Justice Menon said, and reasonably found, that as the case progresses, there is a serious concern about whether she will in fact return when those consequences are at hand. The defendant made extensive efforts to avoid apprehension, not knowing what the charges would be, not knowing that the people would recommend 15 years, not knowing that she would face 25 years. That was before she was ever apprehended.
I mean, the reality is she's, I think, approximately 25, 26-year-old woman. She was living in the city, someplace in Queens, in an apartment with her fiance. She grew up in Long Island. Her parents, her aunts, her grandmother were there. I mean, she knew what happened. She was conscious of what happened. I mean, is it that surprising that she might have gone to be with her family?
Well, Justice Kapnick, it's more than that. In fact, it's much more than that. She took down all of her social media. She then took down her wedding website, right, despite the fact that she was planning to be married in June.
Correct.
She then fled to Long Island, not to her parents' house, but to a family member's house. I submit that the reasonable.
I mean, from Queens to Long Island, it's tough to call it
fleeing. I understand, Judge, but she also turned off her cellular telephone and left it off for days. That, I submit, is because she knew that if we had gotten a trap and trace, as we did, that would have indicated where she was. That is not normal under any circumstance. And we're talking days after the incident, after she saw.
So, I mean, this all happened, and then they went to Judge Gaffey, who asked her to post a significant amount of bail, which she did, and then she came back. So what changed when they got to Judge Menon, which I think we've all kind of been asking since the beginning?
Well,
Like,
Your Honor,
why did she change her mind? I mean, all those things were there before they showed up before Judge Gaffey.
Well, Your Honor, I think, first of all, Justice Menon was sitting de novo. And so I think Justice Menon was making her own decision about what she thought the least restrictive means would be, as she is entitled to do under the law. And of course, the question here is whether Justice Menon was reasonable in that conclusion. This is a habeas court, and the review is incredibly limited.
Right,
The other points I would make, though, is that, again, before the defendant came in on the date of her arraignment, number one, contrary to what counsel said, she didn't know what the grand jury evidence was. That was not available to her until that day, so she didn't know the strength of the evidence or what her fiancé had said in the grand jury. Number two, she didn't know that we were going to start out with a recommendation of 15 years. And I think those facts, the facts that the evidence had strengthened substantially, the fact that she is now facing at least 15 years, those were absolutely reasonable bases upon which Justice Menon could rely. I should also mention, Your Honor, that the legislature itself has now instructed courts to consider whether the charges involve serious injury against an individual in deciding the least restrictive means.
I understand.
And that was another change, Your Honor. That had not come into effect. It had not even passed at the time that Judge Gaffney considered bail. And so that, I think, is another reason why this court should affirm. And if there are no further questions, I would ask the court to affirm. Thank you.
Thank you. Mr. Idala?
Thank you, Your Honor. The people are confusing her actions pre-apprehension to post-apprehension. Yes, she did go to her family's house. Yes, she did take down her social media, which, according to all of the 20-year-old interns in my office, that's what you do when you have a fight with a significant other or you have problems at school. That's what young people do these days, is they shut down their social media. Yes, there was a state of confusion with their family, 100%. But once she was wanted, once it came out in the New York Post that she was identified, her picture, the next thing her family did was call a sitting judge and said, we want to surrender our daughter. That sitting judge called me. I then met with the family, and I said, I'll surrender her on Monday. And since the day of her surrender, she's done nothing to try to evade or avoid or anything like that. Your Honor, Judge Pitt, you asked, should Judge Menon have talked more extensively about her decision? Absolutely. That's what it says. It says it's supposed to put in writing or orally. Why are there no less restrictions? Why can't she wear an ankle bracelet? Why can't she come to court every day like we asked? She's touched on getting counseling. We said, well, she has counseling. She's going to counseling, and she's living with her parents. She said, well, what efforts could her parents make to make sure she's here every time? Well, her father brought her the first time. Her mother brought her the second time. When we argued in front of Judge Bybin, her mother, father, grandmother, aunt, and one other person were there with her. They say that she didn't know what happened in the grand jury until the day of her arraignment. It's her current fiance, who she still lives with, who testified in the grand jury. Do we think she doesn't know what the testimony was in the grand jury? Of course she knew what the testimony was in the grand jury. Do you think she didn't know that the offer was going to be 15 years? She was speaking to Arthur Idala, Barry Cammons, John Leventhal, and John Esposito. Between the four of us, it's almost 175 years of legal reasoning and legal experience. I nailed it on the head. I said, they're going to come in and they're going to start with 15 years. And she came in with zero problems. And, Your Honors, I am not coming here asking you to ROR her. I'm not asking you to set $100,000 bail, although I think she would come back and put ROR $100,000 bail. I'm asking you to set $500,000 bail, reinstate it. And if you just want to know where Judge Menon's mind was, at the end of when she remanded her, Mr. Leventhal said, Your Honor, could you not exonerate the bail so we can go to the appellate division? She said, no, I'm exonerating the bail. So just so you know, that $500,000 is somewhere right now between the city of New York. So
Didn't Judge Bybin said she would exonerate it?
She said-
I thought that was the end. I thought that was at the end of the
You're
transcript.
correct, Judge Kaepernick, but that was like 2 weeks after Judge Menon already exonerated, so we don't know where that money is. So even if you set bail, it's not like the money is there. They don't have that kind of money. They're going to have to wait to find that check, wherever that check is in the city bureaucracy, and then they'll set the bail. All I'm asking, Your Honors, is you're the only ones to make sure at this point that this criminal justice system doesn't do an injustice because this is a media case. Because to be honest with you, I'm in that courthouse 3 days a week. If there was no media involvement here, she wouldn't be charged so high. There would never be a request for remand, and Judge Menon would have never remanded her. Thank you very much.
Thank you. Thank you both very much.